down on Crescent Boulevard, there's a sign that says private beach.
Yeah.
And I'm trying to determine whether or not it's a private beach.
Okay, folks, you
Okay.
are live, and the conference caller is up and running because I'm on that phone right now. Thank you.
Okay.
Thank you, Matt.
Thanks, Matt.
Hi, everybody. Welcome to the East Welcome, everybody, to the East Hampton Town Trustees regular meeting. Today is January 25th, and I'd like to open with a Pledge of Allegiance. Matt, flag, please. I pledge allegiance to the flag
Flag.
United States of America,
America.
to the republic
for which it stands,
one nation,
under God,
indivisible, with liberty and justice
for all.
Thank you, everyone. Arlene, can you do roll call, please?
Sure. John Aldred,
Here.
Francis Bach,
Here.
Ben Dollinger,
Your intelligence and
Here.
Rick Drew,
Here.
Tim Garneau,
Here.
Jim
What I
Grimes,
thought is an initial meeting with everyone there to try and feel where
Jim Grimes?
people and to lay of the land might be a little bit awkward.
Someone's not on mute.
More people in the room that were posturing and so forth, but thinking about it out loud.
Jim Grimes, are you here?
Yes, I am.
Hi, Jim. Mike Martinson,
Here.
Susan McGraw-Keeber,
Here.
and William Taylor.
Here.
All here.
Okay, thank you. We'll start with public comment. Matt, is there anybody on the phone lines?
As a matter of fact, there is.
Okay, well, let's start with caller number one, please.
And caller, you are live.
Hello, caller. Please introduce yourself.
Hello, my name is Mariah for Climate Jobs New York. I'm running in tonight ahead of the needed resolutions for the community benefit.
Very hard to
the South project. And I'm just here to lend a big thank you. We're a big supporter of the project and the good union jobs it'll bring. And we're looking forward to working with you all to see it through to the finish line. And for all of your work for the years, especially on this project.
Hey, well, thank you very much. Is there anyone else, Matt?
No, there's not. Thank you.
Oh, okay. All right, so I think we have Rick Whalen first on this agenda.
Okay.
You're here on behalf of Cynthia Crane regarding a dock at 864 Springs Fireplace Road.
Yes, thank you, Francis. So there is a dock at the property at 864 Springs Fireplace Road that's on Accabonac Harbor. There's been a trustee permit on this for the dock for a long time. Apparently, there have been sort of a discrepancy in the records, but it looks like dock fees have been paid since either 1988 or 1984. The issue that's before us right now is that although the early records simply refer to a 10-foot dock, it's a float, just so we're clear, it's a floating dock with about a 3-foot or 3.5-foot catwalk going out to it. The recent trustee records refer to a 4-foot by 10-foot floating dock. The dock is actually 8 foot by 10 foot. And what we're trying to do is get the records reflect, your records to reflect the size of the dock that exists. Just so you understand, Cynthia bought the property in early 2020, so actually a little less than a year ago. The dock, my office actually did a property analysis before she bought the property, before she went to contract. So we did find the trustee records referring to a 4-foot by 10-foot floating dock. but the dock that was actually present on the property at the time was and remains, because it's the same structure, 8 foot by 10 foot. We also went back at looked at old aerial photographs, some of which we forwarded to you online. You probably know this. The Suffolk County GIS has aerial photographs online that go back to, they go back to their 1962 photos. At that time, there was no house on the property and no dock. 1978 and 1984. The house was built in 1979, and a survey was done in 1979 or 1980 by Walbridge, which shows a dock. It's very unclear about the size of it, but it does show a dock. The 1984 aerials are black and white, and they're very resolution. You can't make out anything about a dock on the property at the time. So all of our evidence on aerial photographs comes from 2001 forward. Those photographs, the GIS photographs, are always taken in the early spring, typically March or thereabouts. So the dock was never in the water, but in all the photographs, and we only sent you 3, but you could look at the Suffolk County GIS. I think there are about 8 different years that are covered. It always shows the float on the upland because it was taken away. So was the catwalk and the wood and the dock restored on the upland. And in all cases, you can see on the aerials from 2001 forward, they're clear enough. You can see the dock. You can actually measure the dock using the measurement tool on the county GIS, and it's always 8 foot by 10 foot in size. So our hypothesis is that somewhere along the road, somebody either inserted or made a mistake concerning the width of the dock and put down 4 foot by 10 foot. So that's all, whatever process is involved. This is the dock that's been on the property since at least 2001, last 18 or 19 years. This is the dock that was there when Cynthia bought the property. And, obviously we would like to legalize the existing dock. So that's really what the request is.
Rick, I looked at this, and what was most striking to me is that the property is actually not adjacent to the water, and this walkway to it crosses town property. How did that occur?
So the owner of the property, a woman named Cynthia Faye Wilder, bought the property in 1978. It had been in the Talmadge family before then. She did a subdivision waiver, I think it might have been 1984. She already had her house. She built the house in 79 and had a pathway. You can see on the photographs, even the 1984 aerial photograph, you can make out the pathway. So she had a pathway. The pathway predated the subdivision waiver. And in the subdivision waiver, you're correct. The planning board created a reserved area along the edge of the marsh, which is owned by the town. Her pathway predates that, and the dock itself, of course, except for the upland edge of the of the catwalk, the dock is on trustee land. So the dock predates the subdivision. It predates the dedication of that land to the town, and that's been the case for the last 30. If the subdivision was 1984, and that's the date I recollect, it's been that way for the last 36 years.
Okay.
So Rick, is there a type of a deeded access or easement from the town or whoever that outlines this area?
No, I've never seen. I've never seen any kind of an easement. I've just seen the access. Predated. What the town would do in the case of a scenic easement, if you have a structure, and so I'm analogizing here. If you grant the town a scenic easement over part of your property, and you have a pathway or a structure that's there beforehand, the town code says that the structure or the pathway predate the easement, they're allowed to remain. So, in this case, it's not an easement. The marsh was actually dedicated to the town, but as I said, the owner has continued to use the pathway for access to the dock since the subdivision.
And that was her intention when she donated it, to keep access?
We presume, because she did, in fact, she's continued on Wilder. I'm trying to think of when. I don't know how much longer she owned the property, because the prior owner, the owner before Cynthia, before Cynthia Crane, that person did not purchase from Wilder. So I think they've been I think Cynthia is the 4th owner since the subdivision. But, all of them have maintained the dock. They've all used the pathway, through the town through the town reserved area.
So what type of documentation would the trustees want to have for the file? I mean, I don't know if, Chris, you can weigh in on this also, just so we have a proper trail, because when you look at a survey or tax map, it just looks like a disconnection that was described earlier. So we just like to make sure that procedurally, I think we're doing this correctly.
Can I just comment here at this point? I saw a permit in the file from, I believe it was 1984. Arthur Roth was the signer. And that permit authorizes a 4x10 dock or float oriented parallel to the shore. Doesn't say anything about a walkway to the dock. So my interpretation of that was that they in effect authorized a float. That's kind of what I saw on that 84 permit.
Can I give you, I don't know how many of you, I'll say go back that far, know the origination of your regulation of docks. So let me give you a little bit of history, because I did know a couple of the people who were very involved with that, notably Stuart Forple and Kathy Lester. In 1983, the Democrats took control not only of the town board, but also the town trustees. For decades prior to that, the trustees were a Republican-dominated board. And they actually continued to be after 1985 until obviously relatively recent time. Republicans usually had a majority of the trustees. But in 1983, which was a very contentious election, the trustees got either a 5-4 or I think it was a 6-3 majority on the trustees, and they maintained that the next 2 years. So when Stuart and Kathy, those were the really the most active players in the trustee board at that time, they came into office in 1984. One of their goals, one of their things that they had was one of their, talking points in the election, is they wanted to, for the first time, take records of private docks and bulkheads that were on trustee bottomland. Before 1984, the trustees had no official records or no reliable records of what was on trustee land. So they started in 1984 by having subcommittees go out to the different harbors, find out what docks, I think this happened in the summer of 1984, go out, locate docks on trustee bottomland and measure them, and then notify the property owners. And there was publicity involved in this, that they would hereafter, if you had a dock or a bulkhead on trustee bottomland, the trustees would charge you an annual fee. And that's the basis of what you do today. So the permit in 1984, I suspect, was not a permit to construct. It was a document recognizing that there already was a dock in place. As to the measurements, I don't know how they, presumably they went around the harbors in boats, and you would think they would have measuring tapes with them, but no one, you'd have to go back and find somebody, if anyone's still around from that trustee board. I don't know if anyone's still alive, and find out how they did it. But they could have made a measuring mistake at that time. The earliest records that I see that Arlene sent us only refer to a 10-foot dock. There's no cross measurement. So actually, I guess John, you said that there was some cross measurement in the 1984 permit. You said it said 4x10.
That's what I read.
So I mean, that's where this all began. Before 1984, the trustees did not charge annual fees for docks. And because in 1984 is when, for the first time, the trustees of the board actually went out and inventoried all the docks and bulkheads that were on trustee land. So, I mean, obviously, we're not able to explain the discrepancy, but as we've said on aerial photographs, and the town also may have aerial photographs in the planning department offices from the 1990s. They have, they used to have prints. Those might be high enough resolution. You might be able to look at those. But from 2001 on, it's very clear that the dock that is on the property now is the dock that's on the, was left on the upland every winter. And you can see it, you can measure it, it's 8x10.
Hey, Rick, that's great. As usual, you're a font of trustee history and knowledge of the trustees. So thank you. Just from my perspective, I just don't want to see us at odds with the town over this, and just want to try to, make sure we follow procedure. And if we need to get a letter or something from the town, maybe we should just try to make sure the file's complete.
I will note, Arlene did send me a copy of a letter in 1909 from John Courtney as the trustee attorney who wrote to, who did he write to? He wrote to the town attorney's office asking them saying that he didn't find any records of the existence of this dock. Although he admits in the letter that the trustees have been taking an annual fee on it since 1984. So the town would have no record of a floating dock built in 1979 or 1980. The town they were not permitting those. They weren't regulating them. And of course, in 1980, that also, the Natural Resources Special Permit Law didn't take effect until 1984.
Rick, I have an aerial photo of the property with the dock. I would share my screen for everyone to see it. I think that helps for the visual aspect of it. So here we go.
What year is that, Susan?
I'm going to tell you in a second. I just got it off the internet. Do you see it?
Yep.
Okay, so,
Yep,
so there it is. It was on the market a while ago. At the bottom of the picture, you'll see it's not on the market any longer. And I'll have to go to my to the source. But that's the property, and as you can see, there is a little walkway here.
That looks like part of the catwalk.
Crosses over. It must be. It adds on to the end of this, and then you have this dock, this floating dock area.
Right.
So,
Yeah, it looks like it's 8 feet wide.
yeah.
It's 8 by 8.
I actually went out there this
Or 8
evening.
by 10.
I actually went out there
8
late
by
this
10.
afternoon, and it is 8 by 10.
Let me just.
Have
It's
you
still in
been
the water.
paying a fee every year?
Sorry?
Have they been paying a fee?
Yes, I believe so. I think Cynthia paid the most recent year, and while who was before her? Yeah, I think that annual fee's been paid every year from at least 1988.
Hey everybody,
Yeah,
it's Chris Carrillo here. I've looked at this as well. I looked back at all the aerials I could drum up, and I would agree that it seems that regardless of the language of the permits, that the 8 by 10 dock is what's been there as far back as we can see. I don't really have much issue with correcting the permit language. I think it's logistically, I think it makes more sense anyway. I don't think a 4 by 10 dock really does much for you. My concern and what I'm a little unclear on, Rick, is more the history of this catwalk walkway and jurisdictional issue and permitting issues there. Is it, are you asking for a permit from the trustees there as well? Is there something that you're going to be asking the town? So the history of the walkway is what's a little more unclear to me than this 8 by 10 dock.
So we have even less records, obviously, about the catwalk than anything else. It doesn't seem to show up in any of the permits. But here's what, although if you look at the aerials since 2001, you can see that each winter, in addition to the float being put on the upland, it looks like there are segments of the catwalk that were put in the upland too. And you can kind of see that in Susan's picture. One of the that's probably the connector link at the end is on the ground. So I don't have any historic records of it. All I would say is this. I can't imagine that anyone would have a float right off the shoreline and have no way to get to it. So I assume, I'm just assuming this, that the catwalk was part of the dock from the beginning, or at least from very early on. As long as there was a floating dock there, they had to have a catwalk to get to it. So I assume everyone just treated the catwalk as part and parcel of the floating dock. I mean, obviously, if you're updating your records and you ultimately agree that what was there is legal, I would like to have your records accurately reflect the fact that there's a catwalk going to the float. But I don't see how you could use the float without the catwalk.
Yeah, I don't disagree. I just don't know how trustees can permit a catwalk on town property.
We cannot.
I interpreted in reading that permit from '84, where it said the 4x10 float dock oriented parallel to the shore. I interpreted that, and this is purely my interpretation, that the trustees couldn't really authorize a catwalk because it was off-town property. So they allowed the float to be placed along the shore, close to the shore, so someone could step onto it. Now, that's kind of my interpretation of why they wrote that permit the way they did.
So
Also,
Can
I
we-
just want to point out, I put a picture up that was taken this past weekend, Saturday. If you can see it, it's from the side. I'm still
So-
sharing my screen.
So trustees, in my opinion, then we can permit the floating dock as we have, if you guys decide you want to have the 8x10 language in there. And I don't think we make any record whatsoever of any permitting for catwalks. And if Rick decides he needs to have it permitted, he can go to the town and get it permitted. But it seems that it's not our jurisdiction and not our issue.
While you're talking, I'm just recollecting. I believe I'd have to go back and check. I think we got a C of O. We got a C of O for the property when Cynthia bought the property in early 2020. And I believe I have to go back and check. I think the C of O, I can't check my files right now because I have to log in. But I think that the C of O reflects the dock, because I think we had the dock put on. We might have even had the prior owner reinstall the dock so the surveyor could show it on the survey. And I think it's shown on the survey in which the C of O was issued.
But they wouldn't have any language as to any improvements not on the subject property.
Yes, I mean, it's, I don't, again, I'd have to look at the C of O.
well, hey guys,
I think we were interested in reflecting the dock, but I have to check the C of O.
it seems like we don't have any problem with the dock and everything else is between you and the town.
If we can circle back to the issue being what is actually on our property is the float and the interconnect. And if we can vote on that, well, then whatever future issues, it's between Rick, his client, and the town. And if then nothing else, us validating this thing will be a supporting doc for Rick to tidy up this whole CO.
This thing is before the code enforcement now. And I don't know if, I kind of personally rather see what they come up with before we go retroactively.
Well, yeah, but let me point out something about code enforcement. Okay, code enforcement will pursue a violation until such time as either an owner or their agent or their attorney can demonstrate that this is a pre-existing non-conforming situation with Rick. Correct me if I'm wrong. You're on that trail and you pretty much have documented that.
Sorry, documented what, Jim?
Documented the pre-existing status of what the code enforcement may be interpreting as illegal structures.
We've certainly not been cited. I don't recall whether we got any kind of correspondence from code enforcement. I'm actually trying to look at my files right now. But it's not like we're in justice court in this. We're not. I'm trying to see if we got it. I'm trying to look for for the C of O that had been issued. I'm not finding.
One other piece of information I'd like to relate is that stretch of marsh is on the stretch that I walk on the mosquito larvae surveys for the last 3 years. And that current walkway is a relatively new walkway. And I wouldn't be surprised if it was installed by the previous owner in anticipation of the sale of that house. And I think that's probably one thing that code enforcement is going to be looking at. So.
Well, the only thing I would say, John, is if you look back on, I'm trying to look at some of the aerials here. We only sent you a few of them, but 2000.
I see some aerials, Rick, as well, where there's pieces of
Yeah.
walkway stored in 01, 04, 06, 07.
I'm looking at 07.
But those are probably different, probably older, maybe wood walkways sections, and looks like maybe the owner, went ahead and got a new walkway and made it out of aluminum or whatever. So it probably is a new walkway, but the use of walkways, I do see back to 01 at least.
Right. I mean, I obviously can't guarantee that the existing structure is the same that was there before, but
Yeah.
I don't think that it was, the catwalk was just installed when this thing went on the market. I mean, I think it's been around for much longer than that.
A catwalk was there. A catwalk was there 3 years ago. A new catwalk was there this past year. That's what I'm saying.
Okay. Yeah, I can't speak to that. I guess what we can do, I'm not sure whether we did. I'm looking to see if we had a C of O that was issued in connection with the sale, and I'm not immediately finding it. There was here it is. There was a C of O issued to the prior owner in 2017, and I'm see if I can blow up the survey here.
Share another picture here.
But Rick, I could see how the CO would be issued regardless. Come out and take a look at the property, look at all the improvements, and they wouldn't even need to look at something that was not on the subject property. So I could see how it would be CO'd. Was the dock there? Yes. Was it on the property? No. I don't know that the CO really benefits you much in this.
Right.
I just posted another photograph of the walkway and the floating dock.
John, is that what the walkway looks like now, or is that an old one?
No,
See some
that's the new
missing
one.
pieces.
That's the new one. It's aluminum.
We have a different picture that I can share that was taken this weekend. If Susan stopped sharing, it says I can share it.
Oh,
it's a lot more extensive. It's worth looking at.
This,
Yeah, no.
I believe 1984, maybe I'm wrong about that, but in this general time frame, with this board at the time that Rick related the history to us of, was also, I had to point out that the same board, this was the time they put the prohibition on new docks in Accabonac, as well as other harbors. So this is all of a piece, I think, that we have to look at it all as a piece. I mean, I'm kind of uncomfortable with the concept of if that board approved a 4x10 dock and then put a prohibition on new docks in this harbor. And then in the intervening years, the dock morphed into an 8x10 dock with a catwalk. And now we're kind of finding out about it. I'm personally uncomfortable with retroactively authorizing it just because it's there.
Hey, Arlene, can you put that photo back up,
I have it.
please?
Yeah, I'd like to address John's comments there. And first of all, that's a very good point, John. And that's part of my point here is in 1984, I don't think any docks have been approved in Accabonac since 1984. So the fact that there's a permit here from the trustees for a dock or that they were accepting fees for the dock, to me is evidence that the dock predated those regulations. And we have the Walbridge survey from 1979 or 1980. I assume what happened is that when Cynthia Wilder built her house, she went ahead and put in the dock right away. And the trustees accepted that it was pre-existing, because if it wasn't pre-existing in 1984, it wouldn't exist. You would not have permitted it. The other point is, John, you just said it, we're finding about it now. The trustees have been taking fees on this property since the 1980s, all right? And we pretty much know definitively that since at least 2001, this float has been the float on the property. And I don't think you could have gotten to it without a walkway. You've been taking fees for the last 18 or 19 years. When you say you're just fine about it now, don't you do annual inspections? I mean, we have to rely upon, you know, the owner's got to rely on something. I mean, granted, in this case, there was a permit for 4 foot by 10 foot, but it was 4 foot, it was 8 foot by 10 foot for the last almost 20 years, possibly longer than that. What's your obligation to notice that?
Well, let me ask, can I ask Arlene this question? Is that dock, the fee on that dock by length or by square footage?
We're
Well, we
only
know that
charging for a 10-foot long walkway, $3 a foot, so $75. They're not paying for a square foot, 8
So
by
that's
10 would
to
be
me-
square footage charge, and then the length of the walkway to it, whether it's 26 feet or whatever's over the water. The 16 feet, I believe the owner wrote, 16 feet out to the 8 by 10. So haven't been paid correctly. For a 16-foot walkway and an 8 by 10 square foot times $3. We've been
We're
paid
getting paid, we're
$75.
getting paid for 26 feet of dock?
No, we're getting paid for
10 feet, right?
$75 is our minimum fee. We were discussing at the last meeting. It's our minimum. So, but for the 10-foot length, should only be charged $30, but we have a minimum of 75.
Okay,
But when you go to an 8 by 10 float, that's you do the square foot there, and then you times the square foot by square footage.
okay, can
By
I
three,
interrupt this?
240?
Can I interrupt, please? This photo that's floating around on the screen right now shows 2, 4, 6, 8 pilings. I'd like to know where they came from, because they're not in the previous photo. And this photo was taken this weekend.
And it appears to be fixed. It's like more of a fixed walkway with a removable piece leading up to it and then back down to the dock.
Right.
So it looks like there's 2, 4, 6, 8 pieces that are fixed.
As far as I know, it's all removable. But the photo on the left, that's what I saw when I was there today. I've never seen the dock in the water before today. So when I saw the dock when Cynthia was buying the property in 2020, the dock was, you know, on the upland.
Yeah, but normally, Rick, you know that the trustees charge per piling. We don't have permits for pilings on this one.
I don't know what your fee structure is. If that's true, I don't know.
But my point is that there's clearly been improvements without permits from the trustees.
Well, based on those photographs, yeah.
The original dock structure could have been for a floating dock, just like duck blinds. You have floating duck blinds and you have bank-based duck blinds. It's really a very similar principle. It could have been permitted like that originally.
But Rick, the other photo that was up previous to that doesn't show pilings. It's just little stakes.
Well, it shows little metal pilings.
Yeah.
Metal rolls. It looks like it's
I know it's really a lot different than the original permit. I agree.
Can I make?
What was the original photo taken? The older photo.
I don't know. That's Susan.
Oh, well, I have to go to Google and I'll look it up for you. Hold on 1 second. Let me just go back to photos. Here's the walkway, as you can see. Oh, hold on a moment. I'm sorry. I need to share. So let me go here and share this with you. Okay. Back up here. Here's the walkway down. Let me just go back to the original that I found.
We don't need a tour, Susan.
I know. I'm trying to go back to the original.
I gotta tell you, for $2.5 million, I really would have thought they would have delivered a dock in good shape.
Okay, so this was what year? Whoops. Okay, so I took it from here. It does not have a year on it. There is no December 19th, 2020. So it was this past December. Oh, well, nope. This is the newer one. Okay. Let's see. trying to find the rest of the pictures. Okay, let's go down here. There's an aerial. Here's the dock here. You can all see this, yes?
Yes.
Okay. And I'll just run past here, sorry. I think in this particular, this is the newest as of December 20th, and there's your dock and your walkway.
Not really seeing much though.
Yeah, I'm sorry, on this particular,
This house for sale again?
sorry? Well, this is
Yes,
December
This house is for sale again.
December 2020. So this is the latest version.
Hey, can I make a suggestion that we table this and let the Acabonic Committee sit down with Mr. Whalen and perhaps his client, work out the history on this property and bring this to our next meeting so that we have actually a neat, tidy proposal in front of us in terms of the timeline attached to this property and what's gone on. Because we could spend all night here reviewing the various real estate pictures here and probably get nowhere. We do have other things on the agenda.
Yeah, let's take it to committee. Rick, I'm available to meet with you anytime. This is Rick Drew.
Yeah, and that's that. I totally agree with what Jim said. We'll cooperate and work with the committee, provide whatever information you'd like.
Sounds good. Why don't we touch base tomorrow, the next day, Rick?
Okay, that sounds good, Rick.
Thank you very much.
Thank you.
Thank you.
All right, next up we have Maddie Narvellis. I'm sorry, Maddie, I can.
No, you're good. Narvellis.
Tyler Armstrong and John McGinn regarding application for Mr. McGinn and Mr. Carey at 275 3 Mile Harbor, Hog Creek Road to construct a new dock in front of their home.
Yes, so good evening, trustees. Thank you for hearing us. I think it's the third session that we have been discussing this proposed dock. And I'm not going to therefore sort of go over all of the details. I will quickly remind the trustees that the dock we're talking about is going to consist of, as you've had in your plans for months, a floating dock, 4 feet by 24 feet, catwalk, 4 feet by 40 feet, and an aluminum ramp, 3 feet by 20 feet. And so the total length will be 80 feet during its seasonal use. And all of the construction with the ramp and floating dock will be with untreated materials. As mentioned, the ramp and floating dock will be removed during the winter months. And I know that the last time that we did come before you, there were specifically some concerns that we are looking to address now that we are back before you. The first of which I think was really the concern that we provide some kind of mitigation in terms of shellfish in the area, whether we would be willing to provide any covenants and restrictions in an attempt so that in that very close area, the number of docks could be kept to a minimum. Tyler, my colleague and our client, who you will meet in a moment, did actually go out into 3 Mile Harbor and did a study of properties and how many of those neighboring properties would also be eligible to apply for dock permits. And in the meanwhile, we had also been asked for some clarification as to the total number of piles necessary for the dock and catwalk. And I promised I would actually come back to you with a number on that this evening, and that is straight from our engineer, Drew Bennett, 13 as a total for the dock and the catwalk. I think I know we're going to have some specific questions for Mr. McGinn with us tonight, and I thought maybe what I would do is actually introduce him along with Tyler Armstrong, because I would like the two of them to certainly cover the work they did in looking at and literally physically going through the harbor. The other thing I just want to add is that we did meet with Ed Michaels, the town harbor master, because given some concerns, we did want to make sure that we would have the town's blessing in terms of issues of navigability and whether there would be a problem there. And Mr. Michaels said that we absolutely would not have an issue. So I just wanted to bring that back and to the board's attention. And I think maybe, Tyler, if you want to talk about the study that you and John did, and then we'd like to have John address the board as well.
What do you call it, Maddie?
Yeah.
Do you have, you mentioned this conversation dialogue with Ed Michaels. Did he give you any written draft expressing his sort of support? Or,
actually, when I asked him, he said that as a representative of East Hampton Town, he was not allowed to do so.
Okay, well, you know what? I do take a little offense when somebody comes in here with a sort of a hearsay testimony. It really doesn't carry a lot of weight. If Ed wants to come in and pay a visit to one of our meetings, I think we'd be glad to hear from him. But I don't think it's really appropriate for you to come in here and tell us what Ed Michaels said without having him present.
Point well taken, Jim. If he was able to get permission to do so, would the board welcome his presence at the meeting?
Absolutely.
Great.
Great. Okay. Yeah, it was a productive discussion with Ed, but I understand. Wanted to hear from him yourself. So we'll, you guys can always approach him, and we talked to him about possibly, writing something or coming in here. So I'm sure he's welcome to, willing to provide his input to the board directly if you request it. Yeah, we have John here. I think that's one of the big things tonight. We provided you with a lot of information since we last met regarding some of the answers to the questions. And John and I had a really nice time going out and just kind of double checking some of the depths out there on a very, very low tide. So that was productive. We went along the eastern side there because there were some concerns about, whether or not properties there could reach the requisite depths within the 80 feet that the town allows for the dock length. And we ruled out a good number of the properties over there based on our measurements. So I know, again, we're two guys going out there, doing our own sort of ragtag assessment, but it really made us confident that a lot of the depths south of John's property are not, not deep enough to support the depths the DEC and the town requires for floating docks. So I think.
Hey, Tyler, how deep was it off of the subject property dock? Did you guys do a proposed dock? Did you guys do some measurements out there?
No, because we already have soundings from David Saskis, so it didn't seem necessary to go up there and do that. We really only went up to, I think, to Shagwong Marina. We walked along the school.
Great. So yeah, what type of vision is there for boating activities at the dock? Is it more sailing orientation, boating, fishing? There's so many opportunities on 3 Mile.
Okay, yeah. Well, that's one of the things we brought John in to discuss. So let's introduce John and get onto that part. John McGinn, we have you here tonight. Want to say hi?
Everyone. Thank you very much for having me to your meeting. I actually was trying to make the last meeting and wasn't able to at the last minute. So I gave a statement to Maddie and Tyler to pass on to you. And I'm not sure if you were able to read it yet, but just in the interest of not repeating it in case you already had seen it, a big part of that note was a thank you to you all as people who are here doing great work for the community and for the East Hampton Town waters. So I mean that very sincerely. We've lived on the harbor. I said in the letter 15 years. It felt like 15 years. It's actually closer to about 12 years. But we love the property. We love the harbor. We don't want to do anything to put the water quality at peril in any way. Tyler and I had it was actually kind of a good time in November when we went out. It was a very informal ragtag is the right word. Try to assess the depths of my neighbors' properties to the south. But I do want to just thank you both for the consideration tonight. and then also for your approval of the emergency repair for our bulkhead, which is they're just about to start that work in the coming weeks. So thank you for that as well. And I do want to say, I mean, I appreciate that you guys have a hard job, and I don't have any. I'd like you, if you feel that we've met the requirements and it's completely your discretion to approve our application, we would be so grateful. But again, I mean, I feel like we're a part of the community, and you know, we will, you know, think of you guys as neighbors no matter what, and of course defer to your judgment. So I just wanted to say that up front, and I'm here to answer any questions you guys might have.
Hey, John, this is Rick. Are you a boater, a fisherman, a sailor? What type of boating activities do you enjoy?
So more of a boater. You know, my father was career Navy, and I grew up sailing. So I like sailing, and then also just recreational motor boating. So you know, we don't have a boat now. You know, when we bought the property back in, I think we closed in 2011, but we'd been living there as renters for several years before, next to Bud Levinson, who was just to the south of us. We had an assessment done by a gentleman that you guys may know, Billy Hayjack, who was looking at a lot of things, because when we bought the house, it was in really bad shape, and we bought it with an approved addition. So we had him just check that out. But one of the things he learned when he did that work was that the property was zoned for a dock, which we were delighted to learn, but we understood that nevertheless, and Billy also caveated this, that it was completely at the discretion of the town trustees. So we kind of had this slow motion process of, I mean, we've had David Saskis' team out to do soundings probably like 4 times at this point. And we've, you know, so we started the approval process years and years ago. We haven't really been driving it too hard, but we would love to have, now we have 2 small kids, and we're spending more time out there, and we would be grateful to have a dock just so we could, you know, at a moment's notice, you know, take a small sailboat out, or if we end up buying a small motorboat, being able to like take it out right from our property without having to drive down the road to one of the neighboring harbors.
Mr. McGinn, just to kind of bring up some of the dialogue we had with Maddie and Tyler at one of the previous meetings. You know, one of the offers that was made was that, well, you wouldn't have any trouble with people doing clamming or oystering around your dock, which, you know, it's not really an offer, because basically we don't, if we give you a permit for a dock, it comes with all of the public access to the bottomland, okay, not to your dock. But as part of that discussion, it was mentioned that you purchased the old Blatt or Osborne property to your north.
That's right. We haven't actually closed on that, Jim, but we are in contract for it.
Okay. Well, John, you know, as part of that dialogue was, well, you know, how does somebody like yourself offer some mitigation to this board, to the ZBA, to why the dock makes sense? And one of those things would be to basically sterilize another piece of property for the option of a dock. And question for you is whether you would consider that as a path to getting your dock on this property.
The short answer is yes, absolutely. We actually were not in the market to buy that property next door. We weren't trying to. We were very happy with our property, but Mr. Blatt, our neighbor to the north, decided that he wanted to sell it, and he found a buyer, and the buyer wanted to basically clear cut the property and buy the wooded parcel from us that's on the road, and clear cut that and put a tennis court in. And so we were we've been trying to really restore the property.
That's pretty inspiring to buy your neighbor's property.
Well,
if that's what you know is coming down the pipe.
Yeah, well, the selfish. I mean, the selfish part also is that, you know, the noise of the construction and whatnot. But we really love the property. We love that part of the harbor, and we don't want to. And, you know, we're blessed to be able to be in a position to do that. But we definitely are trying to be good stewards of the land. We've been there now for, you know, since again, 2008, I think is when we first started renting it. And we tried to start pulling out invasives. We put in a lot of native Long Island landscaping. We've tried to do that. There have been other covenants on the property that we've tried to honor. So the short answer, Jim, to you is absolutely. We would not want a dock there. We're not looking to put a dock there. And if that was one of the conditions of the approval, we would absolutely agree to that.
Well, I think that to me, that's one of the things personally, that if I were looking at this, whether as part of our board or another board within the town, those are the kind of cards you're looking to trade on. And I would think that would carry, to me, that would carry real weight.
Yeah, that's a huge thing.
Yeah, I mean, John has no control over what his neighbors do, of course, but he has control over the properties he owns, and if he wants to sterilize the property to the north, I think it's a nice mitigation. And in addition to that, we've talked to the John Barley Dunn of the Shellfish Hatchery, who we talked to about doing some kind of shellfish bivalve sort of mitigation as well, and he recommended that the best way for John to do that would be that, if he built a dock there, to participate in the residential oyster grow program and grow oysters on the dock, pay the fee to get the oyster seed and the equipment, take care of oysters, have the dock actually, act as something that will increase oyster habitat and not negatively impact water quality, but actually have a possibility of increasing water quality over there.
I'll add also that you do have a copy of the email from Mr. Dunn with his permission. And so that what Tyler just added is something that you do have in writing, yes, which describes how that program would work and what Mr. McGinn is willing to agree to in terms of the shellfish mitigation aspect.
And I think, John, you expressed that you'd actually enjoy growing oysters.
No, exactly. No, I mean, it was it's not even that's not even a give, because it sounds like a plus. I think it sounds like I'm glad they have the program.
Yeah, there seems like there are some good qualities to this project. How everyone else feels. Do we want to take it to committee one last time and come back to a vote on something like this? Is that an unreasonable timeline?
No, and I think whatever happens here, if there's a motion for the dock, it should be generated from the committee.
I mean, I think going to committee one last time and polishing it up and then coming back is path forward. John, what do you think?
That for me, I'm fine.
John, do you have a closing date on the property to the north?
So, no, the issue is that between us, there is a they're trying to get a C of O on the property, and they need to get it. They need to do that basically. There's no issues that relate to. It's all with the structure. It's not, as far as I know, anything with the landscape or nothing with the waterfront. So as soon as he gets the C of O, we're going to close.
All right. Yeah, I think you may have some over clearing issues over there. I know that, the property was manipulated a bit post the Osborne family, which would have been after, I think, 2004. So
yeah, when they bought it from someone bought it and flipped it, they bought it from the Osborne family, and then they did a lot of stuff we were shocked to do, because Billy had us by a tight leash and wouldn't let us do anything. Like, we were really, we wanted to anyway, so it was fine. But they kind of came in and really did a lot of work. But they got a C of O from that somehow. But there's been apparently other things that he's done since then. Nothing major, but
yeah. Hey, it's a process. Yeah, you didn't buy your property from Bud Levinson, no, did you? There was an interim.
Bud sold it to an English gentleman. His name was Dominic Maras.
Okay, that's who I remember was right. Dominic, because Bud was a good friend of mine.
Yeah, Dominic's a great guy. And then Dominic, if you recall, Jim, he had this wonky renovation he was going to do on the house. He'd gotten approved somehow. But it would, in our mind, and I know you guys aren't architectural review, but it would have changed the whole character of that section of the harbor. So we kind of kept it as it was built back in 1910. And so, but they were going to make it like a modern kind of crazy thing. So
yeah, I think that, let's face it, the issue with your property, there's no way you could build a house that close to the bluff face today.
That's right.
And I think that was where Dominic ran into trouble because, you know the topography of your property. You push the house back, it starts to fall in the landscape. You start to lose some of your water view. It's a balance.
Yeah, that's right. Well said.
It does look great over there, by the way. I hadn't been there in a while.
Thank you. Yeah, we love it. We feel very lucky to be in that house.
Okay, so we have a motion to go back to committee for one last discussion and then take it to a vote. Is that what I'm understanding?
That sounds good.
I'm good.
Okay.
Thank you, everyone. Again, I'm really grateful for your consideration.
Okay, John, are you okay with that? McGinn? John McGinn?
Yes, thank you.
Okay, great.
Okay, so any other questions tonight on this?
All right, thank you, guys.
I have none. Thank you.
All right, thanks, everyone. Thanks for having us.
Okay.
Have a good night.
Have a good night.
Good night.
All right.
Good night, everyone.
Excuse me.
Looks like next we have Eric Brown, Scott DeBon.
Well, I think we have Jim Walker on the hook here
Yeah,
right
there's-
now.
Yeah, we have James Walker holding. If you want to take this call.
I'd like if we could. This will be a quick one, I think.
Does Scott want to give up his time?
He's pretty reasonable.
Yeah, we're fine. Whatever you guys want to do. Hi, Jim. Hey, everybody.
Eric, thank you.
Here. We're just shooting the breeze. Do what you need. I'll keep an ear out. You tell us when you're
All
ready.
right.
All right. Jim, are you in?
Hang on, I gotta let him in. I just wanted to wait for your signal, so give me a second, please.
Hello.
Jim,
Hey,
you
Jim.
are on.
Francis.
Hello.
Hey, Jim.
Okay. I'm calling in today to ask for Devon Yacht Club, same maintenance dredging project that I've processed since 1984. I don't think anything's very exciting or different, but it's 1,200 cubic yards of sand. It gets pulled out of the channel at the inlet and gets put on the beach. And Devon Yacht Club has, in the recent past, made the sand available for the town trustees. I think that's about it.
Hey, Jim, do you guys still have to clean off the boardwalk down there as part of this application?
Jim, that's 100% correct. Yeah, I forgot about that. I didn't start that permit in 1984. That's a more recent one. But the sand goes in the same spot, Jim. They clean up the sand that gets on top the main dock, and they put it over on the southeast side of the inlet jetties. And in that manner, it becomes part of the sand that's available to the trustees. I don't
I'd
know
like
if
to
the
make a motion
trustees
to
will.
approve this, if it's okay with the rest of the board, if there's no questions.
Anybody have any questions on this?
No, this is, the same thing we do every year.
There's absolutely no changes, Jim?
No, there are not.
Okay.
There are no changes. I did notice when I was paging through the permit calendar for this club, we are coming back to the trustees to renew the jetty permit. But for this project, no, everything's exactly the same.
Okay, thank you. What do you want to do, Jim Grimes?
I've got a motion on the floor to approve this.
I'll second the motion.
All in favor?
Aye.
Anyone opposed? Okay.
Right. Thanks, Jim.
Okay.
Thank you.
Thanks a lot. Good night.
Good night. Okay, so now we'll get back to Eric Brown and Scott DeBriner. Request for a permit modification to trustee permit GP number 4-20 for Phragmite Management to reflect conditions of the East Hampton Village permit issued to the owners of 24 West End Road on Georgia Pond.
Evening, everybody. Scott and I are here. This is a program that you guys looked at and approved for plantings. And in the course of getting the ZBA sign off, Billy Hayjack had suggested in his comments the installation of this fencing system, temporary fencing system, which I think, and Jim Grimes knows far more about this than I do, is designed to keep waterfowl in particular, I think, out of the plants, therefore giving them a better chance of surviving. Scott and I had not heard of this before, but it's something that Billy asked us to consider, and Jim has indicated that you guys have approved this type of design in the past. So our client is fine with it as long as it is in fact temporary, which I think is one of the requirements of any permitting. So we're in front of you to talk about it.
Hey, Eric, this is Rick. I'm on the Ponds Committee. How you doing?
Hey, Rick.
Good. So the wildlife fencing that we've approved in the past, I believe, has been more of a winter season where waterfowl are overwintering. They're hungry and they're, willing to work a little harder for their food. What is the proposed timeline for such fencing, calendar-wise?
It's actually on the plans. I'm looking at
right
now.
Here you go. In place from October to April.
Great. Thank you, Scott.
But I mean, we would defer to you guys in terms of whatever you know. So happily enough, our client is happy to put it in, but obviously doesn't want it there all the time. I don't think anybody wants it there all the time. So if there's if you guys want to include in something, a specific time limitation, we're open to that.
It's only a one-time thing.
Yeah, there's been a couple of jobs that were really nice, and the wildlife fencing kind of blended in with the shoreline, and the upland buffer was really nice. And there was one in particular that kind of looked like a Bengal tiger trap. And I just think if we can work with something that fits into the character of the shoreline, that would be helpful.
Hey, Francis, I need a call here. Is it possible for me to comment on this? I'm recusing myself from any votes on this project. We have been involved in it in one level or another, but I can speak to the need, to the purpose and the timeline of the proposed fencing.
Hey, Jim.
Yeah.
If you're going to speak to this, can you describe this to us? Because I'm not clear.
Well, okay, we've employed, I've been involved in a couple projects that we have used this wildlife fencing, and this board has approved it. Now, the goal on this is, this in all likelihood would be a project that's probably planted sometime between mid-August and mid-September, ideally. And it typically coincides with the arrival of some of our migrating waterfowl, as well as some of our resident geese population. And the problem you have here is those birds see what really are fresh plantings. It's no different than throwing cracked corn out on the ground. They come in, they set up in that shallow water, they sit and basically work the bottom and pry any of those new plantings off the bottom and eat them. So the goal here is twofold. One, to keep the birds from sort of dropping in on this area, and the other is to keep them from swimming in. But as mentioned by Scott earlier, it is not, as I think some property owners have tried to disguise in the past, it is not an exclosure fencing to keep the public off of the property. And that's why the temporary nature here. It is only for the period of establishment on these plantings. And typically what we as a board have tried to do with this stuff in the past is let the property owner remove the fencing coincidental to our late seasonal let, our spring let on the pond, when you can get access to it. And in that way, it's gone It's gone literally by the second or third week of March. It doesn't reappear. The only situation I could see that happening is if you had a planting that had failed to some degree and needed to be redone. And now you're in that dilemma where you have the exact same situation the following year. And we did have that at the Bengal tiger enclosure, which this agent was not involved in that project. But I think what you can expect here is a successful planting, a successful exclosure, and a timely removal of those temporary structures.
No, it sounds like there's a willingness to work together on this. I think it's helpful to have the wildlife fencing so we can get the shoreline reestablished with native species of plants. And we've made so much progress on Georgia Capon. I think cooperation is the way forward.
Yeah.
And just to be honest, Rick, from Scott and my perspective, we didn't even know this was a thing until Billy Hayjack mentioned it. I mean, it's something that he raised, and then the client wasn't averse to it, and we talked to Jim, and as he's laid out, you guys have done some permitting on this before, so we're happy to participate. Although it was certainly nothing that Scott or I thought of. So
yeah, this sounds like a good thing and fairly routine.
So can I just, I'm sorry, I don't understand this, especially since we've apparently permitted this before. I wasn't on the board at the time, but I probably was. But is this fencing oriented vertically like a regular fence to prevent the wildlife from swimming into the area? Or
Yes.
is it drape over the top?
No, it's John. The depth of the plantings here aren't going to be such that you need that horizontal fencing. It would be vertical. It's approximately 6 foot overall in height. A portion of that fence would be underwater, depending on what the water level at Georgia Pond is at the given time. And at the top of the fence, there may be some colorful ribbons tied to it that flap in the breeze that are there to discourage geese from landing within the given area.
Jim, and how long does the fence remain in the pond then?
It was stated earlier that it would go in probably sometime between September and October and would be removed prior to April 1.
In April, okay. All right, thank you.
The plans specifically say October to April.
Right, I wrote that down, so, okay. All right, wasn't sure. Okay.
The wedding is supposed to take place in March, and just personally, I'd rather see the fencing out more towards April 1st than April 30th. So if everyone is okay with it, I'd like to ask, by April 1 or April 10, so that there is a firm cutoff. We do see gear, not just fencing like this, that lingers in seasons. So, we don't want to get into May, and it may not be anyone's fault, but sometimes it just happens. So I would suggest early April, please.
Yeah, we're fine with that. Whatever you guys want to put in, all I would ask is just put it in the permit so that, but whatever you want to do in terms of when it comes out, just let us know and we're amenable to it.
Yeah, what I'd like to do is confer with trustee council and just, dot the i's and cross the t's and just represent at the next meeting.
Okay.
And I don't see it being a big deal, but I do think it should be done correctly. And I personally, as a member of the committee, I need Chris's help. And
okay.
Sounds good to me.
Thanks.
Anybody else have questions? All right. Well, thank you, Eric.
Okay, thanks. Thanks, everybody.
And we'll see you at the next meeting, I guess.
I guess we will.
Okay.
Thanks, guys.
Good night.
Right.
Night.
Good night.
Thanks.
Okay, Matt, do we have anyone on hold?
Yes, we do. One caller. Would you like to take them?
Sure.
Okay, stand by, please. And caller, you are live.
I spoke previously. Hi, yes, I spoke previously. I'm just listening in.
Okay, thank you.
Thank you.
All right, so we'll move on to old business. Okay, it's going to have a discussion on the public comments from our previous meeting regarding the agreements with South Fork Wind LLC and the town East Hampton Trustees, land lease agreement, host community agreement, dredge sand transportation agreement, also a share agreement with the town. And I think that's about it. We have Dan Spitzer and Milla Buckner here tonight to assist. Dan, do we start with you?
Did you want to go over specific comments that were given to you, or did you want me to just go into my presentation on the 4 agreements?
Well, I don't think we have to go over specific comments. I can tell you that we had exactly 30 people comment. Of those 34 were opposed, pretty much for the same general reasons. So I think we could just move into your presentation if you don't mind.
Okay. In front of you tonight, as Francis points out, is the 4 separate agreements which have been fully negotiated with South Fork Wind LLC and the town with respect to the portions of the wind farm project and export cable that potentially traverse trustee property or trustee controlled property. Just for purposes of the public, although I think everybody knows this, but again, since this is a public meeting, the South Fork Wind Farm is to be installed in federal waters about 30 miles east of Montauk Point. It's to include up to 15 wind turbines, although interestingly enough, the size of turbines has increased and the size of this project has not, and they're very well may be limited, but it can't be more than 15. And to generate up to 136 megawatts of renewable power to be transmitted via a 130 kilovolt undersea and underground cable to the East Hampton substation of the Long Island Power Authority, where it would enter the power grid. The transmission cable will extend approximately 4 miles from where it comes ashore, 30 feet beneath the public beach at the end of Beach Lane in Wainscott, and traversing underneath town-owned roads to the East Hampton Long Island Power Authority substation. You know, the negotiation of these started before I was involved back in 2018 when what was then called Deepwater Wind approached the trustees in the town and offered a community benefit package of around $3 million in exchange for the real estate rights for the installation of the cable. Following the initial discussions, the trustees have been fully and completely involved, and really have to say from Milla and myself, it's been an honor to represent you and to see your commitment to this. Very few organizations have been fully involved with both the state process and the Bureau of Ocean Energy Management process and have had such an effect on it. A lot of good ideas have come from the trustees that are now conditions, and a lot of good ideas are going to be reviewed at the BOM as part of the DEIS. In terms of limiting impacts. The trustees specifically participated in nearly 10 months of settlement discussions. I would remind everybody, by the way, the settlement discussions are still confidential. So anything that was specifically discussed within settlement remains confidential. But during that extensive set of conditions referred to as the joint proposal were negotiated to ensure that the transmission cable is properly installed, maintained, repaired, and decommissioned in a manner that protects the environment and limits the potential harm. And to give you an example, the kind of conditions that came about as the result of this, there's now going to be a subject, South Fork Wind has committed to partnering with the subject matter experts to perform the comprehensive fishery study examining any impact the project may have on the environment. The definition of the near shore has been changed. The
depth at which the cable has to be buried has to be changed. All of this came from the efforts of the trustees working on behalf of the community. These agreements also reflect the approval of the joint proposal and the selection of Beach Lane as the appropriate avenue for this cable to take. The testimony that was heard confirmed this. Some of it was startling. Basically, the CPW position, suggesting that you should instead allow Atlantic Avenue, is that the Atlantic Avenue route is better because Beach Lane is unsafe. They said that these lines are unsafe, therefore, put it through the East Hampton Middle School and people's backyards, and under 4 separate additional railroad crossings, and under a high-powered existing line in rights-of-way, which they claimed were available, but in fact are not. Everything that we heard at the testimony confirmed from the LIPA experts, from the PSE&G experts, and frankly, even from the more honest experts from CPW, that you've made the right choice. One of the most telling moments, I thought, was when we were talking to the expert who had said that it was potentially unsafe. And we said, well, then why would you put it into people's yards along the Long Island Railroad route? And he said, well, they've already got a high-speed train going through their yard, so what's the big deal? And that's in the testimony. You could find it in the testimony. It was rather a startling moment. I'm fairly certain that's not what the attorney for CPW expected to hear as an answer. But the testimony confirmed that they had not considered the same resources you did. They hadn't considered the impacts on the fact that Atlantic Beach is far more crowded. They simply missed the fact that the dune structure on Atlantic Avenue would be impacted, whereas that would not happen at Beach Lane. They misstated which beach was used more by the public and which would have a greater impact on resources. They completely ignored the ocean responders. In terms of Hither Hills and other points, they ignored those fragile landing points. They ignored the wetlands that would potentially be harmed. They ignored the fact that these other routes were far longer. They interestingly said, well, you shouldn't go down Beach Lane because the state energy plan says don't put new transmission corridors in where they don't currently exist. This isn't actually a transmission corridor as it's defined in the energy plan. But when they were asked, well, what energy corridors currently includes Atlantic Avenue, the answer, of course, was, well, none. Everything that, and I defer to Francis, who obviously testified, and to the others who listened in, Milla, but nothing that came up with the testimony in any way indicated that you had made anything other than the right choice as the least impactful route. The lease agreement does a number of things that puts that route into effect. It's a lease. It is not an easement. It is not permanent. And that was a decision that we made because it's easier to evict tenants than it is to undo easements. And that has been the plan. They have agreed to that. The lease is for a term of 25 years following commercial operation date of the wind farm. It allows for wind farm transmission cable to be installed and maintained at the depths that we requested, with the nearshore definition that we requested, based on the ownership of the property to the sea. The lease agreement ensures that the trustees will be able to enforce the conditions. I want to talk about this because this is something that was really important to us and that is in the lease agreement and the host agreement. You are not dependent upon the goodwill of the state of New York for enforcing the conditions, the decommissioning, or other terms. You have, through these documents, you and the town have taken on separate and other responsibilities as property owners and right to enforce. So the kind of situation that was alleged in terms of the political situation at Block Island in Rhode Island could not happen here because you are in charge of your property, not someone else. And we have incorporated into the lease and into the host agreements those promises from the applicant, regardless of what the state does or doesn't do. That's very important to understand, and it's an important concession. The agreements go forward, assuming that the project goes forward, obviously, but not the initial payments. The initial payments are due 90 days afterwards. So let's talk about the host community agreements, which is with the town as well as the company. From 3 million, we're now at 28.9 million, and with specific benefits to the local community. And I want to again get back to some of the comments that have been made and one of the important aspects of the HCA. And there was even a question about this at the public hearing, an allegation that this is going to be a much larger project, that it's going to feed far more than 15 turbines. The host community agreement limits the installation to a 138,000 volt line. It is not up to anyone else to change that other than you and the town, and it's not one or the other, it's both. So this idea that the EMF has been deliberately undersized to avoid impacts, the property rights that you are granting put the kibosh on anything larger, regardless of what the state and the feds want to do and the company wants to do. So let's be clear that the limitations on the project that we've dealt with are incorporated into agreements that you can enforce. The post agreement will make payment and 2 initial milestone payments of $500,000 each. The first will be non-refundable, is made in 90 days of the host agreement effective date, and the second 90 days of the project construction. Those are split equally with the town. Additionally, thereafter, one of the things, and again, I read a lot of stuff where you were all accused of abandoning the local community. In fact, the host agreement includes a direct benefits to the Wayne Scott community. South Fork will make 2 additional payments to the town totaling $5,500,000 to be put into a Wayne Scott benefit fund. So the community is benefiting, and Wayne Scott is particularly benefiting. South Fork will, these are non-refundable payments following the completion of construction. Thereafter, thereafter, 6 months after the completion of operations, the start of operation, there'll be 25 annual payments to the town and trustees, increasing by 2% a year. One of the agreements in front of you today is the revenue sharing agreement that confirms the 60-40 split of those monies, the 50-50 split of the prior monies, and the dedicated Wayne Scott benefit fund. So there are other benefits. There's going to be liaisons. There's going to be an effort for the developer to require its turbine maintenance contractor to establish a wind farm support facility and transfer vessel base in Montauk. I understand that lease has already been signed. So trying to keep as much of the money from the project within the community has been accomplished. I mentioned the revenue sharing agreement. The last agreement I want to mention is the Dredge Sand Transportation Agreement. And a little bit of a chuckle, if you will, about this, about how my fellow lawyers sometimes behave. The Dredge Material Transportation Agreement, as you know from seeing it, governs the sand dredging operation at Georgia Capon. And it basically says that if you don't do the work because of the hassle of the construction or the impact of the construction on Beach Lane, they agreed to replace the revenue. It's possible to get the trucks in from another street, so it may not have no impact. But if it does have an impact, it protects your revenue. Yet in the CPW submittal to the Public Service Commission this week, they said the construction will stop the regular opening of the pond. Now, Francis testified that the dredging has nothing to do with the opening of the pond. The attorney was clearly confused. We stopped and explained it to him, and clearly they got it. And yet, what did they put in their papers? Well, if there's no dredging, the pond's not going to be open. That kind of, at some point, there's confusion, and sometimes there's deliberate efforts to misrepresent the record. We'll leave it to the commission to sort that out. The facts are that this agreement is a typical mitigation. You may have an impact on an existing operation, you provide that mitigation. All in all, I think this is a very fair and balanced set of agreements. Would I suggest that there would be no impacts to the community? Of course not. But this is an underground line with almost underground and completely, with very strong protections should the cable become eroded, for us to take our own self-help responses at their expense, so that we are not relying on this company should they choose to behave as the folks on Block Island did. That was the worst case scenario. And that can't, this is in your hands to make sure that can't happen. It provides significant funding to the community for environmental projects. And everything you do is in environmental projects, but this is a true increase in wealth into the community as a result of this project in terms of these funds, and specifically for the Wainscott area. So I would conclude by saying that there was some emails today from a member of the public saying that the town lease agreement really was subject to SECRA, and therefore it should not have been adopted. These agreements are not subject to the State Environmental Quality Review Act. They are part and parcel of the Article 7 project. The state legislature has not exempted these things from environmental review. It simply said that they're could be considered as part of the by the state as part of the Article 7, but they are specifically exempt from SECRA. There's the revenue agreement and the pond dredging agreement, the revenue sharing agreement and the pond sharing agreement obviously don't authorize any physical activity. They're type 2 actions anyway. But you have, in my opinion, dotted the I's necessary. You've gone above and beyond. All of the laws that address these things, open meeting law, SECRA, strangely enough, they do not talk about the responsibilities of a 334-year-old trust created by the King of England when they list those entities subject to them. And you have gone above and beyond in complying with them. And ready to answer any questions and to recommend to you the resolution approving these agreements.
Anybody have any questions?
Well, I'd like to start by thanking Dan and Miller for their exemplary service and Chris Carrillo through this process. It's been long. It hasn't come without some hitches. And, let's face it, how 4 years ago we started this process off where we knew what a bad deal was, but we didn't know why it was a bad deal. We knew that there was value to being the host community. We did not know what that value was. We were all probably in favor of clean energy, but it was very hard to couple clean energy with the potential impacts to our beaches, to our fishing community. And there still is potential impacts, but I think the conditions that have been put forth here do put controls on that. And I think the value, the host community agreement, truly brings wealth to this community in a form that's going to allow this board to move forward doing some capital environmental projects, Napeague Harbor, Accabonac Harbor, Northwest Harbor, and to include Lake Montauk. It is not a part of trustee bottomland, but you know what? These are all water bodies that have desperately needed attention for many years. And there has always been that dilemma of where does funding come for some of that stuff. And I think the $9 million plus that we get as part of this deal will give us the kind of clout to develop relationships with other agencies, with other homeowner groups, and perhaps with our own town board to accomplish some of these tasks. And that's really all I have to say on it.
Yeah.
We've asked a lot of questions over the last 4 years, and I think we've gotten them answered.
Jim, we've been working on some dredging projects recently, and it's clear, there's a real benefit to, increasing water exchange and other matters like that. And it really does give us an opportunity to move forward with a lot of work that we've talked about and planned out. And funding's tight right now. It's a great opportunity for our community regarding mitigation, which is what I think some of our responsibility is. Thank you.
Yeah. I'd like to thank all the trustees that participated in taking what started out as being a pretty poorly conceived bad deal and turning it into something really quite good. Everybody put a lot of work. I hear people complaining we didn't bring experts in, but we did. And in a way, we became experts ourselves. And I think this is going to be a really good project. And I believe the trustees are going to do a wonderful job making sure that everything we agreed to gets done.
I would like to come in and back up both Jim and Bill as to their comments with regard to the project. But I have another side to this as well, and I'd like to talk to the public who is watching this evening. I would very much like to thank Dan and Mila for their expert advice throughout this process. It's been very long and at times arduous. Many things have come up. I've certainly learned a lot. I think all of the trustees have. I know the trustees have worked extremely hard. The committee that was meeting with Dan and attending all the meetings, I myself did attend many. And before I became a trustee, I attended all the meetings that were open to the public to hear about the project and to learn myself as much as I could. It has been a great learning curve for me personally, and I have done quite a bit of research. I would like to say on another side to this, beside the projects that we might be able to now do with regard to the harbors and Accabonac Harbor in particular is one of the projects that I'm working on, Northwest, Napeague, and so forth. I think that I just want to share with the public. In August of 2018, I attended the Los Angeles Climate Reality Project, and it opened my eyes to just how necessary it is that we depart from fossil fuels. I've seen the world in a different way. And here in East Hampton, we have a small community. This is going to be a historic project. It's just one of many that will come along the eastern coast of our country. But it's very important. And for me, especially when I ran to give back to my community. And I wanted to involve myself with a meaningful purpose that would help the future of my community. It's given me so much. And I raised my family here, as you all know. But I want to tell you that climate change is here. It cannot be denied. It is happening. We have coastal erosion. We must change our habits. So I am very excited about this small project. It's just one of many that will be taking place. And I have done the very best as a layperson to educate myself in every way possible. I am a certified rescue diver, and I will tell you, one of the things I hear repeatedly is that right whales are being killed because of wind turbines. Well, first of all, we all know, if you are involved with marine life, that as a diver, the right whales and whales, dolphins, they are most of them are dying not from wind turbines, but rather from vessel strikes. And that can be a large vessel or a small motorboat with a propeller. And so I want to lay some of the fears about right whales. I subscribe to NOAA, and it tells you where the right whales are passing through, and it tells the mariners to slow down. So right whales are not being killed by wind turbines. I'd also like to say that artificial reefs, for many years, decommissioned Navy ships have been sunk so that they create an artificial reef, and that is where the fish go. They will lay their eggs on these vessels. The wind turbines will act in the same way when they're installed in the waters. And the Tappan Zee Bridge, many of the pieces were recently dropped into the Shinnecock Bay to create artificial reefs to attract migrating fish. And so that I know because I've seen it myself as a diver. So I'm hopeful that once this is installed, if it is installed, we will see a thriving marine species. And so I just wanted to say from that aspect that I'm extremely happy and proud of my community, that we have worked together, the town board, the town trustees, and we've had excellent counsel. And Chris Carrillo, thank you so much for being a part of this with us, representing us. So Dan, Mila, and to all of my colleagues, thank you so much for all the efforts that you've been doing and working so hard.
Anybody else? I guess having a large board of 9 people really had its benefits this time. When we decided to look for counsel, we put together a committee. They went out, they interviewed several, came back with a recommendation, and they couldn't have come back with a better recommendation. Dan and Miller, you guys have been fantastic through this whole thing. We put together a committee to go through these negotiations. Rick, what the effect you've had on BOEM, I never ever would have expected that we'd have the say that we've had with the federal government on this issue. And thank you so much for that. And John,
thanks, Francis. I appreciate your saying that. It means a lot to me. We've worked together on this. I think it might even be 5 years now. So it's been a long haul. And thank you for your support.
And John, with putting together that fish study is invaluable. And I really appreciate that so much. I'm very proud of what you guys have done. Jim, you've hung in there. You've been tough at times, and we wouldn't have gotten here without you. I greatly appreciate that. And the rest of the board, you know, when we came to you with questions, with information, you asked the right questions. You kept on us, and it's an experience I've never gone through before. And I've learned a lot, and you guys, I just think it's just been the best. Chris Carrillo, I know it's been very difficult for you at times, and I appreciate what you've done. And that's about all I have right now. You guys are great. So shall we go ahead and read the resolution?
Please.
Trustees of the freeholders and commonality of the town of East Hampton. Resolution approving 1, the host community agreement between the trustees, the freeholders and commonality of the town of East Hampton, the town of East Hampton and South Fork Wind LLC. 2, the lease agreement between the trustees and freeholders and commonality of the town of East Hampton, South Fork Wind LLC. 3, revenue sharing agreement between trustees and the freeholders and commonality of the town of East Hampton, and the trustees of East Hampton. And the town of East Hampton. 4, Georgia Capon dredging agreement between the trustees of the freeholders and commonality of the town of East Hampton and the South Fork Wind LLC. Whereas South Fork Wind LLC has proposed a wind farm to be constructed over 30 miles from Montauk Point, New York, the project, to be connected to Long Island Power Authority electric grid through a single 138 kilovolt cable, the cable. And whereas South Fork Wind has requested a lease with the trustees of the freeholders and the commonality of East Hampton in order to allow Wainscott Beach at the terminus of Beach Lane to be utilized by the interconnection cable for the project. And whereas the trustees and South Fork Wind wish to enter into a host community agreement with the town of East Hampton to provide benefits to the community during the construction and first 25 years of the life of the project, including specific benefits for the Wainscott area and the town. And whereas the trustees in South Fork Wind also wish to enter into an agreement to protect the trustees' revenue source from the dredging of Georgia Pond during the construction of the project. And whereas the trustees and the wish to enter into a revenue sharing agreement detailing split of funds to be received from South Fork Wind under the host community agreement, which agreement designates the Wainscott Benefit Fund. And whereas the trustees have participated in the full review of the project by both the state and federal governments, have successfully insisted on numerous conditions being added to the proposed permit for the cable, and have included in the host community agreement and the proposed lease restrictions on the cable and decommissioning requirements separately enforceable by any permit issued by the state or federal government. And whereas the trustees have received comments from the public and the proposed agreements, including oral and written comments at and following a duly noticed public hearing, as well as comments submitted at regular meetings of the trustees. Now therefore be it resolved by the trustees of the freeholders in commonality of the town of East Hampton as follows. 1, the trustees find it is in the best interest of the freeholders in commonality of the town of trustees and do hereby approve the following agreements. A host community agreement between the trustees of the freeholders and the commonality of East Hampton and the town of East Hampton and South Fork Wind LLC. B, the lease agreement between the trustees of the freeholders of the commonality of the town of East Hampton and South Fork Wind LLC. C, revenue sharing agreement between the trustees of the freeholders in commonality of the town of East Hampton and the town of East Hampton. D, Georgia Pond dredging agreement between trustees and freeholders in commonality of the town of East Hampton and South Fork Wind LLC. 2, the clerk of the trustees is hereby authorized to execute each of these agreements and take all such steps as necessary, including filing of a memorandum of lease or any other instruments necessary. 3, the resolution shall be effective immediately. Shall we vote on this?
I'd like to, yeah, I think we should do a roll call vote on this, Francis.
Okay. John Aldred?
Yeah.
Ben Dollinger?
Yes. Oh
Rick
my
Drew?
God, I just come. Yes.
Tim Garneau?
Yes.
Jim Grimes?
Yes.
Mike Martinson?
Aye.
Susan McGraw-Keever?
Yes.
Bill Taylor?
Yes.
And I am a yes. Okay. Passed and adopted by the trustees and freeholders of the commonality of East Hampton on January 21st, year 2021. Thank you, everybody. You did a fantastic job.
Thank you for your kind comments. It's been an honor.
Thank you very much. You guys were great.
Thank you.
Thank you very, very much. I wish we could see the rest of our trustees tonight so that everybody could be seen, and thank you. I do want to say the original meetings that I attended back at Scoville Hall with Rick, Drew, I think you had set those up in our community for everyone to see, hear, and speak to experts. So I thank you very much for my introduction to the project and for everybody's hard work here. Thank you. It's good to see you.
Thank you, Susan.
Yep.
Thank you, Susan. That's very
You're
sweet
welcome.
of you.
I wish I could see you in person so, everybody could see everyone.
Hey, I just want to thank Chris, our general counsel, for his leadership in basically leading through the process that brought us to Dan and Miller. I want to thank Dan and Miller for all of their hard work. Again, we could not have done this without you guys. And I want to thank the rest of our board because, hey, there's been good times, bad times, and I think the thing I appreciated is everybody listened, and I think at the end of the day, everybody respected each other's positions. John, the fish study, it was long, it was arduous, and I don't think anybody else on this board could have dealt with the simple length of time it took us to get to that one point. This has been really good. Rick, you were a prick when you needed to be one. It's not a bad word, Susan. Okay, I looked it up.
It's high praise.
I think we should all have dinner when this pandemic ends and take Dan and Mila and Chris Carrillo. We'll all go out together and celebrate. How's that?
I love that. Yeah, that sounds great.
Good.
Okay, and Arlene and Allison, you join us because without them, we would not be here either. I want to thank them for all their hard work.
Very good point.
I guess I'll briefly put my 2 cents in, and thanks everybody for the kind words to the attorneys who did a great job here. I think just a quick story on my end. I think the highlight for me on this was being on a cooperating agency phone call with BOEM with about 35 different cooperating agencies across the Northeast corridor. And the trustees made a point, and we listened as about 5 to 10 of these other agencies jumped on board and said, yes, we agree with the trustees. That's a great idea. And just seeing our impact in that way was really a special moment for me. And that's my quick story. Thanks again to everybody. And Dan, if you don't mind, maybe just a 2 to 3 minute kind of what's next. We've been so deeply involved in getting to this point. I'm not sure I know where we go from here with Article 7 and BOEM, and maybe just take a minute or two and talk about the next 3 to 6 months.
All right. Thank you, Chris. And let me add to your story that I knew we were having an impact, and Rick in particular was doing a great job when the general counsel of the agency at that time, who was on the call, complained to one of my partners about Rick. And I said, well, we're doing something right. We got their attention. So that's the best compliment that I think you can get, Rick. Next up is, for lack of a better word, litigation. The Public Service Commission has received the initial briefs of the agencies in favor and opposed to the project. These are all online if you want, or if anybody needs any of them. The reply briefs are due in another, I think, 10 days. And after that, the Judge Balsito will write a recommendation. And the recommendation is supposed to be heard by the Public Service Commission at its March 18th hearing, if we stay on schedule. CPW had requested a delay and a stay. The commission ignored the request so far. And obviously the briefs went in without a change in the schedule. So the Judge Balsito has decided to do a recommendation as opposed to a decision, which would, the way it works is if you do a decision, then the parties get to do another round of two rounds of briefing before it gets to the commission. With something this large, there's really no reason to do this. And Judge Balsito followed a path that is also allowed and that he's used in other large cases where he's got all the facts with the records complete, and he simply writes a recommendation. And it saves a lot of time and money by eliminating a round of briefing. We fully expect that certain parties will be unhappy with these agreements, the town's agreements, and whatever decision, one way or the other, that would come out of the PSC. that would lead to litigation, challenging the validity of agreements, challenging the legality of any decision. And the company, as you know, will indemnify. That's one of the provisions of the HCA. The trustees are indemnified for those costs, as they have been for the costs related to the adjudicatory hearing so far. Absent success in any of those proceedings, the federal government is expected to have a more positive view of offshore wind under the current administration. The DEIS comments are coming up in February. The DEIS process and the decision should hope sometime this summer, I would think, is the schedule for that to be issued, which would conclude really the permitting aspect of this. There's a large number of plans still to come in that as part of the permitting process, including the environment and management plan that we will have an opportunity to comment on. And those things will all proceed apace once a decision is made by the two main regulatory authorities. With construction proceeding, as soon as everything's in place and they can get going, some of the construction timing is based on conditions that were approved. For example, there is a condition specifically designed to protect right whales during and limiting construction and the noise from construction during white whale migration season. And Susan's right. Wind farms are not killing right whales because there are no wind farms. There's like 2 wind towers in the entire offshore United States. So all of those things are the pieces that have to come together, culminating in the start of construction and the commencement of the start of the wind farm operating and providing power.
Just to echo some of the items that Dan highlighted, the trustees, in addition, obviously, as we've said, in addition to being very involved with the Article 7 process, will continue to see through the review of the draft EIS and the BOEM process. So next week, we'll start circulating a public statement on some of the comments that we've had on the DEIS so far. And then on February 9th will be the first public hearing from BOEM on that item, and we'll continue to represent our interests and advocate on your behalf in that session.
All right. Anybody else have anything? Okay. Well, I'm glad we're not going to lose touch with you, Dan.
And Mill and I both look forward to seeing you in person again as soon as possible. It would mean that I won't be sitting here in a shirt and a tie and sweatpants doing meetings and get to travel again.
It's certainly been a pleasure working with you guys, and I miss coming out to live in East Hampton for 2 or 3 days on end and living in your community and stuff. I've certainly grown attached to the area where this project's going in and feel a lot of pride on this project in general. So as we've all said, it's been a pleasure.
Well, you'll have to come back and visit with us. And as I said, we'll have dinner.
Love that.
By summertime, hopefully everybody will be vaccinated. So.
Okay. Well,
anyway.
Thanks so much. Okay. Shall we move on to the next piece of business?
Kind of like everything else pales after this, you know.
I know.
It's kind of an anticlimax.
Hey,
I'm going to bid you all a good night. Be safe, be well.
Yes, you as well. Do you still have your icicles outside?
They're still there. I think it was 25 degrees down there tonight. So I'm not down there tonight, but I suspect so. They're supposed to get another 5 inches tonight. So,
yeah. All right. Well, be safe. Mila, Dan, good night. Thanks so much again.
Bye-bye.
Thanks, everybody.
All right. So
Hey,
now we
Francis.
have Kayak. Yes.
I'm sorry.
Sorry.
We have a caller waiting. When you're ready, let me know.
It's not the same person who was.
No, that person dropped and it's now a new caller.
Okay. Let them in, please.
Okay, give me 1 second, please. Nope, I take that back. They just dropped too.
Okay. Thank you. All right. Kayak rules and regulations, overview and discussion. Do we have anything to discuss on that?
Yeah, I've got a list to put on the screen. I sent it around to everybody last week. Is it on the screen?
No, not yet.
Is the list on the?
No, it's not, John.
Here
There
it
it
is.
is. There it is.
Says I'm screen share.
It's there.
Okay. So this first bullet is really this first bullet is well, let me just go through it. Some of these are questions of whether we should put them on the application so that applicants are perhaps more aware of the conditions under which they're keeping their kayaks on racks than they might otherwise be. So the first one is should we put this on the application? Kayaks must be kept on racks only and no kayak shall be left in the grass, etc. Anybody think that should be put on the application?
I think it's good. It's a good idea.
Yeah, makes sense.
Yes or no?
Yes.
Yes.
John, when you say put, John, Chris Carrillo here, when you say put on the
So
application.
the second consideration is
John,
should
can you hear?
kayaks be?
John, Chris would like to say something.
I just, when you say you're going to put that, can you hear me, John?
Yeah. Should this, what's that?
I'm just trying to understand, when you say you're putting that on the application, is it being installed in the application as like an affirmative representation that the permit holder is not to allow their kayak to be left in the grass on some sort of condition that the permit can be revoked? Is that what you're saying? I just don't understand the way it's going to be put on the application.
That's right. Yeah.
Okay. Yeah, maybe I could when we have to get through the list, maybe if you want to send it off and I can help clear it up a little bit. And I don't know if you can't hear me or I can't hear you, but it sounds like it's going on the application.
Absolutely.
All right.
What's that? Yeah, it may be my internet connection that tells me from time to time. Are you not hearing me?
We hear
No,
you,
we hear you.
but you're breaking up. It's your
All right,
Wi-Fi,
so
John.
the second point, and this is not necessarily to put on any application, but what's that?
Your Wi-Fi is breaking up.
The second bullet, am I being heard here?
Yes.
Real time, or am I delayed?
You're
No,
delayed.
we hear you.
Continue.
Keep going.
The second point does not necessarily have anything to do with putting on the application. Is should the boats be put on a rack in a certain places? Should they be assigned spots? That question arose. My feeling is it would be too complicated to enforce that, and I don't think it would work out anyway. But I'm looking for other opinions on that.
I would tend to agree with you, John. It's kind of hard to assign.
I get the feeling nobody can hear me.
We can hear you.
Okay.
I agree with you, John. I think it would be too much, too much to try and keep track of where individual spaces. So I think maybe just again a total number of kayaks on the rack.
Okay. All right, so moving on, should we limit either the width or the length or the weight of a kayak? Some of the kayaks are quite wide and they take up a lot of the rack. One thing I noticed when we went around and, took a look at permits on the racks last summer was there were not a lot of them. There were some kayaks that were very big and heavy. So should we consider a weight limit or a size limit for a kayak?
And listen, if somebody can pick that thing up and lug it to the water, I don't see how we can regulate that,
Yeah, I agree.
One of the considerations I felt was the racks themselves. Are they gonna,
Are they going to succumb to the weight? Listen, I think the racks are capable of supporting the loads. I mean, what does happen, and where those racks have failed, it's because those cross members are just mixed hardwood, and they just, they rot out more quickly than the vertical posts, which are locust. So I don't think there's much you can do about it. But when the wood's in good shape, I think they've stood up pretty well.
okay. The next point is, should we mandate that both be secured to the rack?
I think that's a great idea because
with locks or bicycle locks or.
I'd like to
agree
just
with that.
jump in and comment on this because last year I was called to various places to find stray kayaks that had been either used by someone else or they had just been blown off into the beach. And then, of course, we have Ed Michaels who has to come up and take the stranded or loose floating kayaks that have no owner. So I think adhering them and securing them to the racks would be a good thing because then people aren't, they know where the kayak is and nobody can use it if they haven't been given permission. And it's also a thing about safety for me too. If we have an aberrant kayak running amok, could hurt somebody who's swimming or hit a boat or something. So all your suggestions, John, are very good.
Okay, well, that one was yours, Susan, so.
Yeah, well, I'm thanking you for yours.
Well, a lot of these are Allison's, actually.
Oh, okay. Well, Allison, then good choices.
So, okay, it sounds like we're in agreement with that one. Should we mandate that the owner's name and contact information is written on the boat? And I think that, again, would be an important thing. The same reason that if a kayak gets lost in a storm, Coast Guard, Marine Patrol doesn't know if anybody was with it or it was just lost off the beach. So they wouldn't have to then find a permit number, call the office.
I think that's a really good idea. And I'm kind of surprised we haven't adopted that earlier.
We were meeting with them to try and make the requirements in this COVID thing.
I think
but we could
What do you use to put a person's name?
We're at the point now where the
new applications. Yeah, there should be some way to contact the owner.
Last year, we gave out some stickers. Or at the very least, it could be written on inside the cockpit. Okay, so should we allow year, there was a plan to only limit the number of cars. Previously, there had been permits given out to the extent that you could put 5 on a rack. Ultimately, it turned out last year that there were more permits given out, so there were several racks that had 5 per rack. Again, it's kind of a weight consideration and a crowding consideration. Should we limit it to 4 per level? Would be 8 per rack, or should we just kind of leave it at, you know, if it goes to 5, it goes to 5. And that's really for the, you know, Arlene and Allison to know when they have to, you know, cut people off.
I don't know, John. It seems like it's probably gonna have a lot of people still here looking to recreate in the water. So I feel maybe leaving it as it is, because I did a lot of the inspection in a couple different spots, and I didn't see that 5 was too many.
So we leave it at 5.
I tend to think that it's not.
Hey, John, most wreck kayaks are 30 inches wide. Do we have any dimensions on the racks?
Should we be very strict about limiting? Do we have any what on the racks?
Well, the average recreational kayak is 30 inches
It's
wide.
a 30-inch kayak. It's not bad.
Yeah, that's the average wreck width, even of a double. So, a recreational double and a
Quite
kind of,
often what happens.
single that is not that easy to flip, they're around 30 inches.
There's quite a few tandem kayaks on there. And then there's these inflatable kayaks, which are quite wide.
Yeah, some of them get up 34,
There's a mixture
30.
of types on a given rack.
Right.
Right.
So that spans, what, 12 and a half feet or so to do 5?
I think a rail is 10 feet. Is that right?
They were probably a little short on 5 if it's 10 feet.
I think at 10 feet, 10-foot rail between posts.
Right. 30 inches is 2.5 feet times 5. We're definitely.
Well, they fit, so maybe they are 12 feet. 5 fit, 5 normal.
Right.
Yeah.
So is the
All right, we'll
consensus
leave
that
it
a
at
reduction is appropriate, or are we going to maintain the same?
Should we be strict about keeping the rack, the permits to all?
Please repeat. You broke up a little bit at the end.
I didn't catch all that. Sorry. I didn't catch
Please repeat
the last statement. Sorry.
John, if you can hear me, if you look at the chat box, maybe if you have a question.
I didn't catch your.
Oh, okay, let's see here. Your connection is very weak, John.
John, maybe stop your screen share. I think that might help us.
I think John is frozen.
Okay. Well,
do we table that till next week?
Can you hear me any better or hear me all?
There, we hear you.
Yes?
Yes, we hear you.
Let me try to, there's three we limit this to only kayaks, not give out any permit for canoes or paddleboards. And put that on the application so that if somebody gets a permit for a kayak and sticks it on a paddleboard, we can confiscate it. That's the question.
And I have a lot of friends that love to paddleboard. And, you know, do you ever watch River Runs Through It? You know, I don't see how saying somebody can have a kayak and not a canoe or a paddleboard. It's the same use of the water. Is it causing problems at the rack? I don't understand why that's a problem.
Well, the canoes in particular are generally being stored next to the racks, and that defeats the whole purpose of the racks. And the paddleboards, I mean, we
Structure for different vessels and then, you know, take up more real estate. So if you have a big canoe, you buy 2 spots. You know, maybe there is a density consideration here based on vessel type.
Or the bottom spot on the rack could be for the canoe, and then, you know, the next level will be for kayaks and
So what are
paddleboard.
we gonna do? Charge $500 for a friggin' $600 canoe to store it for the year?
I understand we're trying to keep things neat. I just don't want to limit, you know, my son from bringing his canoe down to the rack if he wants to. In my case, no, that's not the case, but somebody's son or somebody in general. I just feel like as long as it's on the rack, if it fits, it's legit. But if it doesn't, then it shouldn't be tied up next to it. And then enforcement could take care of it that way.
Well, the stand-up paddleboards are much wider, aren't they?
Right.
They
Well, vertical rack for them would be, you know, they are really well suited to a different style rack, and you can lay them in vertically and you get a lot of density. But just back to the kayak rack for a moment, perhaps you could do a size consideration. You say 30 or 32 inches based on the length of the cross beam. So maybe there is a way to delineate how many can fit or your density based on specification of the vessel.
Do we know how many paddleboards were using the racks this past year?
We haven't been allowing them at Louse Point and Girard because we have so many. We probably have 180 applicants for 56
Well,
spots
I think some people bought
But
permits for a kayak and stuck them on their paddleboard.
yeah, we didn't issue any there. We did issue them happily. We can issue anything at Settlers Landing because we have plenty of space there, canoes and paddle boards. And I did issue them at Mile Hill last year, paddle boards. But once again, once that rack went up, I mean, the calls were ringing off the hook, kind of like you said, Francis. People would see a rack and they kept calling. But we did allow paddle boards at Settlers and Mile Hill. Yeah, it's a tough situation.
Hey, Arlene, thank you for that. John, you put a lot of time into this, which is great. I don't know if you're doing this under Harbor Management Committee or kind of independently, but do you think at this point it makes sense maybe to go back to committee and take another look at this under the, you know, the guise of the different vessel types and how to manage them more effectively?
Yeah.
But there is really no committee that I know of that deals with kayak racks. I think, you know, it started out as the committee of the harbor, and now it's multiple harbors.
Yeah.
So
I mean, I think it should go to some level of committee. I'd be happy to get in on it. Mike, do you want to jump in on this one, maybe?
I think, Rick, you're hitting it at the right spot because it spans multiple harbors. I think it belongs in harbor management.
Roger that. Well, I think we should go to committee on that, really, and then hash it out. Is that okay, John?
Yeah, that's fine with me, but we got to do it fairly quickly because they're going to start giving out permits pretty soon.
Understood. Let's get together before the next meeting so we can give an update.
And I'd like to join too, if that's a possibility.
Yeah, that's good.
It's fine.
Tim, you and I have been working on it.
All right. So we're gonna put that, we're gonna table that for the next meeting. Committee reports, beaches. We have a town ZBA hearing for the property owned by Ronald Lauder, 118 Beach Lane.
Right.
Fronts on the ocean and Wainscott Pond to build a home.
All right. Some of you probably recall at our last meeting, which was on January 11th, we got notified January 11th about the fact that we didn't get notified for the January 12th hearing on this project. Susan and I both attended the hearing. I think it was very well done. There was several things that came out on it. It's a case, they're looking to rebuild a 1,290 square foot house on a beachfront property where there was previously a house existed. As part of that application is a proposal to restore the primary dune and maintain it, and also remove Phragmites that's along Wainscott Pond and revegetate that area. In terms of our interests, both of our interests would be served. I don't know whether any of the other members of our board had watched this subsequent hearing on the last couple of weeks. The record is being held open for an additional week, so it's not open just till tomorrow. It's open for another full week if we as a board want to weigh in on this. Does anybody want to take the floor here and express some concerns or support? I don't think we should necessarily support a project if we have a real and legitimate concern as part of our interest to the public. I think we're certainly within our rights to do so. I don't know that we're here to carry a banner for anybody other than perhaps notifying this applicant that it didn't come up in the public hearing, but they do need to get a trustee permit for that beach restoration work and any restoration work they're going to do on Wainscott Pond. So that's all I got. Susan, maybe you want to add to this.
Yeah, I'll just, it was very interesting, the zoning board meeting, and I would highly recommend, if you're interested, that you tune in and watch it. It was at 7 p.m. on December, what was it?
No, it was on January 12th.
January, excuse me. Yes. Let me just see here. It was January.
12th.
What was it?
The 12th.
The 12th, thank you. At 7 p.m. So if you go to the Zoning Board of Appeals, Brian Frank spoke to the project. I actually had a conversation with him just to fill in a few of the questions I had, but apparently this is a lot that is a buildable lot that Mr. Lauder owns. So while Jim said it did have a house that was considerably larger, not by much, the new permit application is for 1,500 square feet, 1 story. It will have a 2-car carport of sorts, sanitary system and driveway. And it does have a lot of freshwater wetlands, barrier dunes, beaches, and beach vegetation, which has grown in quite a bit, apparently since Hurricane Sandy. I have concerns with regard to the history of it. When Sandy came through, it not only went through the parcel itself, but it went directly right into Wainscott Pond. And so this is a very fragile lot, and I have concerns while it is a buildable lot, and Mr. Lauder would like to build something on it. I'm sure just having the permit would increase the value of the lot itself. I'm concerned that everything that we do as trustees now is to limit the new buildings that are directly on the ocean, especially in a lot that is filled with wetlands. So our concern from my position as a committee member for the beach is, how does this impact us as trustees? And then, of course, Jim and Rick, you're on ponds, right? For Wainscott Pond, which we have no access to.
Correct.
And we retain Dr. Goldbler to do the water sampling of Wainscott Pond, and I was unaware that we have no access to the pond. So
to give a little history on this application, we actually did get noticed on a hearing that was scheduled in 2018 on this property. And the application was withdrawn at that time. And there was a moment where the applicant's counsel had approached the CPF people about the possibility of donating this property to the town of East Hampton. And for whatever reasons, because one of the conditions of the gift was that the town would have to take on the responsibility of maintaining that barrier dune, that gift was declined, or perhaps it maybe not even was declined. I think Mr. Lauder may or may not have retracted that offer. But I'm just going to put into the way I look at this thing is part of this application is that the applicant commits to maintaining that barrier dune, okay? In the absence of a house being there, there isn't a whole lot of incentive to maintain that dune. And what that dune does protect, it protects Wainscott Pond, it protects the surrounding floodplain. And that in itself could be considered a benefit to this board. The proposal to do the restoration work on Wainscott Pond was a condition that was not generated from the town. In fact, Brian Frank actually spoke against the Phragmites cutting or removal and restoration at this particular application, which the comment was made that we would be disturbing the property too much, and he would rather see that taken out and then come back and do that work at a later time. And I'm just going to tell you from practical experience, there's no better time than if the house is going up to do the mitigation work on the wetland restoration. From my standpoint here is you've got a property owner that in his other endeavors along in Wainscott Pond and his participation in this community has kind of demonstrated himself to be a pretty good steward of the land. I quite frankly did not see a reason for this board to basically go against this or to weigh in accordingly. I didn't really see the benefit, one, to this board or even the benefit to the community. If anything, I saw it as a possible detriment, because what I do see happening here is if the day that dune overwashes, if we were part of anything that impeded the reinforcement of that dune, I don't know whether we couldn't possibly be named in a lawsuit. I wouldn't want to find myself there or see this board find itself there in the future.
It's a good point, Jim.
So Jim, will there be the need for any trustee permits for
yes, there will.
beach management and for possible Phragmites or other pond remediation for the floodplain?
Actually, what did not come out of the ZBA review, and it's not necessary, is the clear fact that if this project does go through, it not only requires ZBA approval, it will ultimately require trustee approval for the beach restoration work, and it'll also require trustee approval for the Phragmites work as well.
It seems like it might be an opportunity for some cooperation with the homeowner and upland landowner there that, may really end up benefiting the public.
Well, that's the way I looked at it. And if you looked at the applicant's site plan, it's really a case where the house is surgically cut in there. There is no yard, there is no lawn, there is no, there's just a small driveway and a few basically conservative parking spaces. And you have, I believe it's a 1,290 square foot house with a 550 square foot or so deck.
There's still a lot of,
Well, actually, the deck is 971 square feet and the house is 1,500 square feet. It
No,
is a
the house
one-story
isn't, the house isn't 1,500 square feet.
Yeah, I'm reading it right here.
Are you sure?
Yes, I'm reading it right here. This is the
Because
application.
they shrunk it from being 1,300 and some square.
No,
feet.
no, no. Well, I'm reading it right here. Description: to construct approximately a 1,500 square foot elevated one-story residence with 971 square feet of decking, a sanitary system and driveway on a parcel of land containing freshwater wetlands, barrier dunes, beaches, and beach vegetation. They will require a natural resources special permit and variances with minimum coastal setbacks. This is coming right from the ZBA itself. Primary barrier dune crest setback variances are required to construct the residence.
there's still like remnants of the house there.
Land includes, you said?
Yeah.
The
The
said the
house,
land includes beaches.
yeah. Having them reconstructed doing sounds like a really good thing. It's gonna have to get the sand from someplace, right?
Yeah, I think it's in the littoral drift too, Bill.
Yeah.
Well, it also does help satisfy the conditions of our Army Corps permit.
Yeah, that'd be nice, yeah.
Also in the ZBA meeting, I noted at least a 60-foot scenic easement was suggested by Brian Frank. There was no mention of a scenic easement for this property. He would like to have seen that in the application. But
I think that was, Susan, that was stuff that was basically agreed to, and some of that on the discrepancies on coverage was a part of the reason the applicant's attorney asked for an additional week,
right,
as opposed to the 2-week keeping the record open, to actually keep it open 3 weeks, because the applicant needed some time to basically level the project.
mm-hmm.
We don't really have to speak about the house except to note we have no objection to it. We come in with the.
We don't need to speak to anything, really. If it doesn't, the house, the only things that really are of interest to the trustees is there clearing upland of the wetland that's going to impact our asset? Is there clearing of the beach vegetation, which ultimately may jeopardize our beach? That's probably the realistic extent of our interest here. It is the ZBA's and natural resources realm to deal with the setback, deal with the scenic easements in the areas that are outside of our jurisdictional review. And in both cases on this application, the beach was being proposed to be restored. Any disturbance as part of the construction and installation of the sanitary system was being proposed as being restored. And the Phragmites removal along Wainscott Pond, again, was being proposed as being restored. The weak links on that was the Phragmites removal. There was really no described methodology there and no described restoration. Those to me were the issues.
Is there enough natural vegetation in the area that it would come back?
Probably not, Bill, because I'll tell you what, if you look at an aerial of this property, it's got two pretty dense, well-defined clumps of Phragmites that if you actually look at like the 2018 aerials, or go back to Sandy and what it looked like around then, those areas of Phragmites have probably expanded considerably from what they actually showed on their site plan.
Hey, Bill, we see a lot of projects on Georgica Pond that we've done the Phragmites management on, and we're not seeing a lot of natural recruitment except in a couple of areas. So we haven't had a great track record there, and the need for more restoration-oriented projects, seems to be the future if you're looking to get, more native vegetation in place.
Requires some plantings when they remove it.
Yeah. That may be part of it. So I think the trust. The pond is part of the review. That's the one point, Jim, I wanted to add. I think the pond is something we need to consider as well.
Well, and you know what it is?
Thank you. That's exactly what I was just going to bring up, because as the owner of the bottomlands of the pond, we are neighbors then to this property. So that's our position, isn't it? That we are neighbors, and therefore how is the pond going to be impacted when they start to do construction? And basically when they start bringing the heavy equipment in, it's going to destroy a lot of the indigenous plantings that have come back since the storm. And how does it impact the pond?
Susan, if you get down to this property, it's probably more inhabited by non-native invasives than it is native vegetation. There is native vegetation mixed throughout this process. The construction of the house and the sanitary system were pretty well described in terms of how that was going to be done. And as part as like a standard boilerplate, anybody's required to sort of describe and demonstrate the metes and bounds of the proposed clearing and disturbance, and install sediment controls in those areas. So in terms of the disturbance beyond the metes and bounds of what's described in the application here, it's not going to be much other than there's going to be some grading that Brian picked up as part of the installation of the septic system that's going to need disturbance beyond what they actually showed on that proposed site plan. But I just want to point out, this is not a pristine site. The site has been disturbed many, many times over the years. I think there's an opportunity here for this thing to get some restoration work on it.
So what do we want to do now?
I personally felt that this was something that we didn't necessarily, our job wasn't to act as a cheerleader for the applicant or the ZBA. I think the hearing brought the facts to the surface and gave the ZBA board enough information to act on. If anything, I thought our response here should really speak more to the need for trustee permits for the two areas, the beach and the wetlands, and leave it at that.
Okay.
I think that'll be forthcoming as the project moves along.
I agree that we shouldn't speak on behalf of the project in any way.
There's something we don't have to vote on that, do we?
Unless we wanted to. I think the way we left this at the last meeting was, were we giving up our rights to weigh in on this project by not challenging the noticing requirements on this project? And the answer to that question was no, we were not. Okay, because the record has been kept open. There's been the opportunity for us or the public to weigh in. After hearing all the facts, I honestly didn't feel that it was something that served our interest to do so.
And our main concerns will come into play when they need to apply for permits for
that was the only thing
the pond work.
Yeah, and Francis, that was the only thing that didn't come out. A lot of times, Brian, one of the planners, will bring that up at a public hearing and say, this is a project that not only requires our board's approval, DEC approval, perhaps Army Corps. It also requires East Hampton Town Trustees approval. There was I don't recall any mention of that at the public hearing. If we're going to weigh in, that may be the letter that we write to the board, is to remind them that we are not just neighbors here. We are actually interested parties beyond that. That this is a project that does require trustee approval as well.
Are you recommending that?
Keep it at that.
I am recommending that, yes.
Yeah.
Okay.
You think we should specify that any work on the pond or dune restoration will require trustee permits?
Yes, I think
Not
that's
mention the house at all.
Well, I think that's the house we don't really have a specific interest in.
Yeah.
I didn't see where it was jeopardizing our interest, our interest in our assets there. But it certainly was something that does require trustee permits, and I think our silence in that respect could leave the door open for somebody to think they have the permits when in truth they don't.
Yeah. So we should just write the ZBA a little.
Yep, that's all. We have 1 week and 1 day to do that.
Who's going to write the letter?
I can talk to Chris tomorrow about writing.
Okay. All right. I think we beat that up. Georgia Capon 2021 Phragmite Renewal Program. Want to talk about that or table it?
Well, we've got quite a few. Rick had gone through some of Bruce Horowitz' applications, but we've got a whole bunch of them that we just plainly and simply haven't done the site visits at this year that we do need to wrap up this month or between now and mid-February.
Hey, Jim, I'm going to follow up on the ones up by Hog Creek. And if you want to get together any Saturday, I'm available.
Okay.
So, Francis, I think we'll have a better update at the next meeting.
Okay. I have you down to follow up.
Great. Thank you.
All right. Roads. Town Line Road?
Yes, Francis, thank you. I know you and I have talked and shared some information on Town Line Road recently, and it is a somewhat complicated area because there's a lot of interests involved. Half of the road is owned by the Southampton Town Trustees. There's airport property, there's gun club property, there's county property, and there's town property, and there's Southampton Town property, and there's private property involved. But I did have a chance to speak with one of the Southampton Town Trustees, and there is a sincere interest in working together. And the Southampton Trustees actually have a budget for someone that does some waterways work and actually also does some roads work for them. So they have a resource to bring forward to possibly participate in a cleanup. And there is an existing gate on the north side of, the south side of Town Line Road at the corner of Industrial Road. And that could be a possible starting point to somewhat, close off part of the road and see how the gate is received and if we can get people to park and use other forms of responsible access. In conjunction with starting to clean up, I think there's some traction here. So I'm going to keep pursuing it. It's been a inch by inch, kind of foot by foot progress, I realize, but I think there may be a path forward to really help make this a more responsible area. It's so beautiful and has so much potential for hiking and other activities. So I'm definitely going to keep pushing forward, and we'll keep updating the board as this consensus is developed. Thank you.
All right.
Look, I'd just like to point out that that gate on Industrial Road there, that southern stretch of road where you go through the gate on Industrial Road, you can go a little bit to the north and then head west onto a local Sagaponic road. That's become quite a popular back way to bridge Hampton. And you can see that if you look at the condition of the road there compared to what it is farther north. So I think that's going to be a difficult thing to do, close off that gate. I think you'll get a lot of pushback. You might get a lot of just vandalism on the gate. So I think that's a consideration.
Yeah, I hear you, John. I've labored over this for the past 2 years, in terms of balancing public access rights and responsible usage. But, when you look at the amount of littering and the burn pits and the damage to the road and the dumping on the road, unfortunately, our community's just not acting responsibly here. And as much as it pains me to even consider something like this, it seems to be the only path forward that's going to realize a result. We can go ahead and do all the cleanups, and if everyone feels that doing all the cleanups without any consideration to access, we may find ourselves in the same place in a couple of years or for a future board. So, a lot of the board members really haven't weighed in on this, and it is lingering and dragging on. So, I don't want to pursue something that really goes against the grain of everyone, but it is something that's, been a problem for quite a while.
Well, I kind of look at this as being some
I'm not advocating
window
anything.
deal. If you leave a window broken, more windows get broken. That maybe we stand behind cleaning these areas up. And we follow through. I mean, crap that's on that road isn't something that all came in one day. That's a case of dumping and stuff over a period of time. I think if we start to show that we have more of an interest in it, let's see how that turns out. And if it just accelerates or aggravates the issues of dumping, partying, whatever, well, then I think we take action on it.
I mean, would clean up and signage?
Clean up some signage. I mean, God, we have so many friggin' signs all the way around town. In some ways, that's a form of littering.
Yeah, but somehow a warning has to go out.
Yeah.
Or we just close the gate off once in a while, just as kind of a warning shot. It's closed during certain hours, Friday and Saturday night or something. I'm not sure. It's something I'm certainly flexible on, but I think we do need to get in there and get the area cleaned up, and maybe putting in a parking area where people could walk the road instead of drive it as an option would maybe limit some of the use. I realize if someone's running an Uber business and it cuts 20 minutes off their ride, well, certainly it's going to be a preferred route. But I don't know, that that's really the spirit of that road right now, given the condition of it and the lack of improvements.
I would just suggest that if there is a consensus to close that gate on the end of Industrial Road, you work with Southampton trustees to also put a gate on that local road in Sagaponic going on to Town Line Road, or some kind of a barrier chain or something like that. So it's clear that from both sides, you're not able to get onto Town Line Road.
Yeah, there's more work to be done there, John. Thanks for pointing that out. So I'll be bringing it up again at the next meeting and hopefully have a little more progress. And, to Jim's point, maybe we get a little ahead of ourselves on the cleanup first and the gate follows a little bit based on how we do. We're going to get into spring and there's going to be a lot of interest in getting outside. So time will tell pretty quickly.
Hey, Rick, this is Ben. Were you thinking about gating the north end of the road over by 114 or just the south side on the Wainscott side?
Just the south side right now. That north road, it's a different animal. This is where we've seen the, egregious behavior, the dumping, the damage to the road, et cetera. So I think this is a stepwise process, one step at a time.
Because I feel like the south end of the road is more just the cut through for people to cut some time off where they're traveling to. And I feel like a lot of the traffic for the vandalism, the fires, and the dumping is all coming from the Merchants Path side. You know, because you have that big steep hill that's super sandy from the Wainscott side, and a lot of cars can't make it up that.
I can make it.
Yep. So, yeah, well, I think one step at a time, Ben. I hear what you're saying.
Okay.
All right. Okay, next we have closing out.
Hey, Fran, can I ask, before we leave the roads thing?
Yeah.
I don't know whether you remember a little while back, we got a request for an easement so that Suffolk Water could run a water main down what was allegedly one of our roads, which was Montauk Boulevard.
Yeah, Chris, I think attacked that today. Is he still here?
Chris did some research on that. He actually ended up calling Rick Whaling.
Right.
Montauk Boulevard is not listed as any of our holdings, and it appears that it's an old filed map. The roads are really urban renewal roads because all of the residents and that the town attorney's office is just giving false advice to the property owners that they need something from the trustees. So Chris is going to put a letter together to send over to the town attorney's office and just like get the record straight that this is not a trustee issue.
Okay. All right. So now, Susan, you want to close out Keene at Lazy Point? And if you don't mind, I'm going to step away for a minute. Okay. You have the floor.
You're muted, Susan.
There we go. Hi, you can hear me now, yes? Hello?
Hello?
Oh,
Yes, we can hear you.
Yes, we got a note from the building inspector's office today that we had not yet closed out the Keene residence at 177 Shore Road. So I took a jump down there today, took some pictures, and everything seems to be in order. So I'm going to just share my screen so you can see what they are, how it looks. It's we had given them a permit way back in 2018, I think it was, and then they finally just finished the work now. We had extended their, it was for a ground level deck. And where am I? I think it's here, ground level deck. And here it is. Can you see this on the left on your screen?
Yep.
Yep.
Yes.
Okay. So they just put in, this was a cement patio and they covered it up and there's the back.
All right. Hey, Susan, originally they had an application in one, there's a concrete patio underneath that
Yes.
the deck that they have right now.
Yes.
But wasn't there an application as part of this for a little rooftop?
Yes, but they decided not to do that. I spoke to Pam today and because I was looking, I said, where's the rooftop deck? And there, she said, when I spoke to her today from the house, she said they decided not to do that. So
I'd like to make a motion that we close this thing out.
and I'll second it.
All those in favor?
Aye.
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 Okay, all right, thank you very much.
Okay. Francis, are you?
Jimmy, you going to take over?
I can. Okay.
I'm just trying to keep it moving.
All right. Yeah, listen, we're on a roll. Payment of the bills. We have Ken Roselle Incorporated for $42,380. This was the bid for the Dredge Pond dredging work. John pointed out at the last meeting, that was left a little sloppy. We did have a little conversation there, and that's something that's going to be taken care of in the next few days. So I would like to make a motion that we go ahead and pay that bill. It's actually getting old at this point.
I'll second it.
I hear crickets.
Oh.
Yep.
I'll second it.
Okay.
All in favor?
All in favor?
Aye.
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 Okay, second bill, Visgreen Materials, Inc. for $40,850. This is the moving of the sand at Louse Point as part of that beach nourishment, that we got the modification on our DEC permit. And this actually doesn't represent a bid price. This is the time and material to move that stuff. And we will be, hey, Bill, how much sand did they actually kick over
I
there?
don't know. We haven't gotten a number yet. Francis was busy working on the windmills.
Okay, but I think, our modification listed as a specific amount of sand that we were.
No, the modification, the way it is right now, we were allowed to move as much sand as we wanted to this time.
Okay.
In the future, the modification will be that we can move 3,500 yards anytime we have to open up an emergency opening of the channel.
Okay, am I correct in understanding, though, that the arrangement that we have with the property owners over there is that they're willing to pay the number $7.50 a yard?
No, the deal we have with the property owners is we send them, we pay the bill, we send it to them, and they reimburse us.
Okay, however you.
The whole thing.
I think that's good. Can we get a motion to approve this bill?
Make a motion to pay Bistrian.
Okay.
I'll second it.
All in favor?
Aye.
Aye. Any opposed?
None. Francis, do you want to jump back in?
Yes, we have one bill left that Francis has, Drew Bennett, so it came in late today.
This one with Bistrian, well, I have to get Patrick to break out how much he dropped in front of each property so that they can figure out how they're gonna divvy it up. So, I'll get that done this week.
All right.
All right. And, Drew Bennett's. We have one from Drew Bennett for $967, DEC permit modification for moving the sand at Louse Point.
Okay.
Motion to pay.
I'll second.
All in favor?
Aye.
Aye.
All right, we have no minutes to approve at the moment, and we were asked to put this financial report on hold till the next meeting. So I think we can look for a motion to close unless somebody has anything else.
Just 1 second, trustees. We have somebody on the phone.
Oh, we have something else too, Francis. Report of.
Oh, okay, yes.
Well, can we
This-
take
the
the
phone caller?
Can we take the caller?
Mm-hmm.
Okay, give me 1 second, folks. And caller, you are live.
Hello, caller.
Hi, good evening. Hi.
Can you introduce yourself, please?
Good evening. Yes, this is John Benedict.
Hi, John.
Hi,
How can we
Francis.
help you?
How are you?
Good.
I just have a couple of things to mention. I was listening to the entire meeting this evening, and the first thing I'd like to mention is I was down at Gerard Point a few weeks ago, and there was still one kayak on the rack. There was another one under the rack. There were two paddles under the rack and a Pelican canoe at the end of the rack towards the north end. And I stopped down there Saturday, and I realized everything was gone. But two of the racks are damaged. One is missing a rail, and the other one the rail broke on. I've noticed I go down there pretty often because I live in Clearwater Beach, and I don't store kayaks or paddleboards or anything there because I keep them in my basement. They're much safer there, and they're protected from the sun, which damages both. And it's sort of hard. You can't really lock a paddleboard to a rack like that. The only things you can lock to those racks would be a sit-on-top kayak that has drainage holes through it, and you can easily cable that to the rack. But I did notice that some of the kayaks that are on those racks are pretty heavy. If you get a 17-foot kayak that's made out of plastic, it weighs probably 70 or 75 pounds. And, you know, a few of those on a rack is easily going to break those rails. And the rails, I noticed, are pretty small. I never really looked at them up close, except for Saturday when I was there. And they're not really heavy enough to handle too many large kayaks. I had a question also about, second question would be about whose jurisdiction would it be the beaches on the bay side of Girard Drive?
That would be us.
That is your jurisdiction. And how far up do the trustees control to the high tide mark?
We generally we claim to the base of a dune.
Or the beach
To the base of the dune?
Or the beach grass line.
No, to the water.
Or would it depend on how far the
water?
No, the other way? Yeah, mean low water.
To the mean high tide mark. Right.
Low tide mark.
The low tide mark.
Yes.
So it depends also upon how much the private property owners own, correct? How far their property extends from Girard Drive towards the Gardener's Bay?
Not necessarily if they've been hit by erosion.
Right. Okay. And
every property is different,
notice,
so you really have to look at each property uniquely.
Right. I guess I'd have to really go down to the planning or building department, whoever has a map of that area, to look at them to determine, you know, which property is public property and which is private.
Anything that is beach, and certainly beyond grass lines at the minimum, will be considered public.
Right. Okay. Also, now the county dredged the inlet in the fall, and they placed quite a bit of dredge spoil on the Louse Point side, but they also deposited a large pile of it on the bay side at Girard Point. And nobody ever removed any of that, correct?
Correct.
Right. Because most of it, I noticed the beach wasn't too bad there before they added that spoil. But afterwards, the spoil was basically a mixture of 50% sand mud mix and 50% gravel and broken up shells. So it's not really the best thing to walk on. Basically, you wouldn't want to walk barefooted on that beach. You'd require hiking boots at a minimum. So could you use that in any way? Could you remove some of that, like, you know, Pat did on the Louse Point side, and utilize it elsewhere, sell it to, you know, homeowners that might need it?
Bill?
Yeah, I thought you were going at the camera there, Bill.
Oh, no. Moving it's a pretty complicated and expensive proposition. You have to get permits, a budget. You need a reason to move it. We'll look at it in April and see what it looks like.
Right, yeah, it's not as large a pile as was at Louse Point, but there still is quite a bit there. It's a pretty high mound compared to the height of the beach originally.
Yeah.
I know that the first two houses that are on, you know, if you consider if you're driving from Springs Fireplace Road and you reach Girard Drive, I would consider that the first causeway you come to, and then the second causeway would be the one with the culvert running under it. The first two houses on the Girard Point side of that causeway really lost a lot of sand underneath them just during a few winter storms this year, and they really need a lot of sand put back there. Are they any of the recipients of the sand from the Louse Point pile?
No. No, the sand from Louse Point was moved south down that beach.
Right.
Down just past the revetments. Those revetments have caused a lot of scouring and erosion. And the adjacent property owners at one time were also applying for revetments to protect their properties. We've been able to work out this soft solution with them to avoid the construction of continuous construction of revetments down there. So we're looking at that as a win for everybody. The beach on Girard is very different than what's down there. There's a large bluff there that needs to be protected. Girard is very flat. The houses that you were talking about that are basically in the water, part of the time, that is considered private property. And I don't think that there's any way that we could move sand that belongs to the public onto private property like that. I think there would have to be some other type of arrangement.
I know they just did that last spring to at least the first house there after Istrians rebuilt the revetment along where the culvert is on the second causeway on Girard Drive, because
they've been putting sand under those houses for 20 or 30 years.
Right. Yeah, it's sort of tough. I always wondered why they put the culvert under that causeway and not under the north causeway, because I always thought it would flush out Accabonac, that end of Accabonac, a little bit better if it was on the further causeway. But that fills up very easily, that culvert. I mean, I mentioned it to Jim McCaffrey when he was clerk of the trustees years ago, and he said, well, that's where they decided to place it, but it hasn't stayed clear for very long. I know it has improved the water quality of that end, but it still fills up every year, and it's a job to dig it out each time.
I wouldn't mind going down at Girard and taking a look and seeing if there's something that might be done. But I think that's going to be a tougher nut to crack than what we were able to do on the Louse Point side.
Yeah, I know one of those homeowners, not the first house that's closest to the culvert, but the second house. They had applied for putting up some kind of hardened structure, whether bulkheading or a revetment, and they were denied it by the planning or the zoning boards years ago. So they're just leaving it as is, and I guess they'll just, somebody's going to have to replenish that sand again, because I can't understand how they allow someone to have a fully exposed septic and cesspool system like that. If you take a ride down there, Francis, it's pretty badly eroded there right now. And the road was closed off after one of the storms. The town closed the road off for a while, so they had cones up there, and So that was a pretty bad hit we had.
Yeah, that's a difficult property, and I think it's an annual thing where they have to recover their septic system and build it up a bit around there.
Right. But they don't really use that house very heavily, but they are there during the summer months, at least. Whenever they're there. As a matter of fact, it'd be hard to get there right now because they might need a ladder or something to get up to the house. Yeah. But anyways, well, thanks a lot for the info. And I thought I'd let you know also that with the kayak racks, I go there pretty often, and the majority of the time, there are very few kayaks missing from either set of racks, whether Louse Point or Girard Point. Most of the people place them down there in the spring or in the beginning of the summer, and they just sit there all year. Very few of the people use those kayaks on the racks. And it's a good way for you to make some money, but I was surprised at how few of them are actually utilized.
Yeah, I don't know if people do early morning usage or evenings. I'm really not sure, but I kind of noticed that the racks are usually pretty full when I go down that way also.
Right. Yeah,
but who am I to say how they use their vessels?
Well, thanks a lot for all the work you guys do, and I'm always glad to see improvements around Accabonac. I did notice I do paddleboard around and kayak around there pretty often, and I have noticed that that dock and the walkway you were speaking to Rick Whalen about earlier in your meeting, and I did notice some changes on that over the years. Originally, it was more wood. Now, a lot of people are using aluminum components along Accabonac on their floating docks. So it's good to see, though, everything's pretty much preserved. It is one of the nicer harbors in the town, and I enjoy living nearby and spending time on the harbor. And thank you all for the work you're doing in preserving our natural resources in the town. And it was good talking to you, and have a good evening, and hopefully we'll have a better year this year if we all get vaccinated soon and things will return to normal.
Okay, well, thank you for your interest, John. Really appreciate it.
Yes, nice way to end the evening. Thank you for calling in.
Okay, thank you, Susan. Bye-bye.
Have a good evening.
Good night.
All right, you want to just quickly hit on the staggering of the election cycle?
Sure. I did send out an email a couple of days ago, and I resent it today to see if we can have another get-together just to discuss what we've done, Chris and Jim and Bill.
And I think both of them had to leave.
Oh, no, Bill's here.
Oh, Bill's here, yeah.
Hi, Bill.
You?
Yeah. Okay, so I'll just tell you, we did have a nice conversation with Chris had recommended a firm, and so we spoke with them. We're waiting for some information to confirm fees and so forth, but they had come up with a relatively very easy way to do this, which is for us to vote and decide for ourselves, and they would help us go through with a draft to come up with something that was legal. But they said that since we are not governed by the town board in terms of making our own rules and regulations to a certain extent, that we could come up with a resolution based on what we would like to do and staggered the terms and vote on it, which we have done in the past. They acknowledged, because they have done some research beforehand, before we met with them, and they felt that was really would be a legal way to do this. It would be easy, and we are not bound by the state, but they did say that we should go to speak to the Suffolk County election board and just confirm with them that they, let them know what we wanted to do, what we were going to do, and would they continue to carry us through the elections as they have been. Bill, you want to add to this? But that was one.
Yeah. I was thinking, a lot of it, nobody seems to be answering some like basic questions about our history, when we went from 12 to 9 and stuff like that. Wonder if we should have a conversation with Rick Whalen about some of that stuff.
Oh, we already did that research with Hugh King 3 years ago. I went through all the old books, so I do have it written down. Trustees just started fading away and they didn't want to, and then at one point they changed the year. I could probably dig it up. The lawyers want to see that, or?
If you have it, I think it would be helpful to send.
Yeah, okay. It was a very casual thing. Somebody would leave, they didn't replace them. But eventually they went and they got their size officially down to 9 then. The first 2 kind of just faded away. And then by the time the third one was fading away, they had to go up to, they did end up going up to Albany and ratifying the 9. So
Yeah,
that was from about 1954 to 62 or so, something like that.
That's the information we need. I'm so glad to hear you have it.
Good. So if you could send that to us, if you can dig it up for us, that would be swell.
Sure.
The other thing is we did speak with Dan, and he's along the same thought path. So I think that those are 2 good situations. We already know Dan, so that's a plus.
Yeah. Well, it'd be interesting to see what they did in Albany, because what they did the last time might be binding on what we have to do this time.
Mm-hmm. Right.
Yeah.
I think they passed the law. They asked permission and then the state reviewed it and said it wouldn't harm anybody if the trustees went from 12 to 9. I mean, that was the real thing. Was it going to harm the public or not? And
well, I'm so glad to hear you have that information. It'll be great.
Okay.
Okay, so that's about it for now. We don't have anything else more to say, but I have asked that we have a meeting among ourselves, again, the committee, so that we can discuss. And then this is another piece of information that we could definitely use, Arlene, to share with whomever we, going forward. But we're working on it.
Okay,
We'll move.
great.
You need a motion to close?
Unless anybody has anything else.
No,
Yeah,
motion to
motion to
close.
close.
Motion to close.
Second,
Second.
Second.
all in favor?
Okay.
Aye.
Okay,
So-
thank you, everybody. Good work.
Thank you.
Hey,
Aye.
Good
Thank you.
evening. Good night,
Great.
everybody.
Thank you, Matt.
great job on the windmills, man.
Yeah, Matt, thank you very much for everything tonight.
Absolutely.
Okay, see you
Okay.
soon.
Bye.